So we have one participant using the symbol waiting to enter into the room.
All right, sorry, this is Judge Madden. I don't show anyone still waiting to enter the room. I think we were still missing one scoring panelist.
All right, I will check with Mr. Symbol to see if he might have signed into the incorrect room. Thank you.
And that echo should stop. I always forget to turn off the live stream, and that's where that came from. But that'll stop from this point forward. Let me just check in. I've got, I think, Jess Falkenstein and Andrew Hilliard. I think our third juror was Martha Nye. I want to make sure I'm not missing our third juror.
I believe we're just missing Martha Nye. I spoke to Phil, the tournament director, and he said he's trying to figure out where she is.
Thank you very much.
You're welcome.
We are still waiting for my co-counsel as well. I believe he is signing on shortly.
That sounds good. I'll keep an eye out. As soon as he logs in, we'll admit him into the room.
Thank you.
Your Honor, I believe Dr. LaGreca should be in the waiting room as well.
So far, no one showing is waiting.
Okay, I'll go ahead and double check with him.
Sorry about that, Your Honor. I got a little lost, but I'm in now.
We're fine as long as you came in now, and I think we're still waiting on our final juror as well, and maybe also one of the witnesses.
Okay.
While we wait, I think it would help certainly for our participants in terms of our jurors, if you're able to go ahead and label not only your name, but also the team number you're on. And I think it helps also if we get you on the side, get the label on the side of the case, if you're able to do that. All right, I think we're just waiting on our one final juror, and I know that Phil's working on that, so as soon as we get our final juror, we'll get started. But feel free to relax until we get the juror. just to give everyone up to date, they're scrambling to move people around and judges. And so hopefully we get a final scoring panelist shortly. I figure there's nothing like a little extra stress right before your third round. Let me check. We've had someone sign in under law office. Is that our third juror by chance?
That would be me. I'll change my name.
No worries. Thank you very much. That way I can check in and tell them we've got everybody. And when we get the thumbs up, we'll start. But thank you very much. And while we wait, if I could check with our jurors, scoring panelists, if any of you recognize any conflicts that you have with our student competitors.
No conflicts here.
And I think we got that from Juror Falkenstein. Is it Falkenstein or Falkenstein? I'm sorry.
Falkenstein. It's a tough one.
That'll work. Ms. Falkenstein, thank you very much. How about from our other two scoring panelists? Do you recognize or have conflicts with any of the competitors?
I'm sorry, just a moment, Judge. Let me take a look at the list.
No worries.
I don't see any, Your Honor.
Fabulous. And for Juror Hillier, and you may be muted, maybe what's happening. Did you recognize anyone on the list?
No.
All right. Thank you all very much. We'll still have to hold off. We're still waiting for the thumbs up. They're moving scoring panelists around, but we'll start soon.
Judge, can I put myself on mute at this point?
I think that's perfectly acceptable. All right, let's go ahead and get started then. All right. Thank you for all of your patience in that regard. Especially, I know some of you were thinking you were running late and it turned out that you were just fine. Let me go ahead and officially get started then, since everyone's here and we've received the message that we can get started. We'll go ahead and call the case of State of West Carolina versus Timothy Ray. My name is Judge Madden. I'm Judge John Madden. Scoring judges, what I'd like to do, and I think you already know this, but there are the two buttons in the lower left of your screen. And we ask that the scoring panelists turn off audio and video, and I think they've already done that. For our scoring judges, they should remain off until the trial ends. And also, you should have your video set to hide all non-video participants. And that way, you will only see the people who are on the screen right now, which should be the advocates and me. What I'd like to do is go ahead and get started with the entries of appearances by counsel, beginning with the state. Let me have entries of appearance, please.
I just want to.
I'm jumping again. Go ahead, Mr. Symbol, go ahead.
Oh no, I think she realized she just needs to unmute. I was wanting to let my co-counsel know.
Good morning, good afternoon, Your Honor. Kendra Jackson for the state of for Skelton County, and I represent Team 114.
Jackson, thank you.
Good afternoon, Your Honor. My name is Yuli Tsimbal, spelled Tsymbal, also on behalf of the people. And as my co-counsel mentioned, together we represent Team 114. And when Your Honor is prepared, we do have a few housekeeping matters and motions in limine we'd like to discuss.
I definitely will not skip those. Mr. Symbol, thank you very much. Meanwhile, though, let me go to entries of appearance by the defense.
Good afternoon, Your Honor. My name is Trey Allison. I am joined with co-counsel Alex Ephraim, and we are here on behalf of Mr. Timothy Ray.
Mr. Allison, thank you. And Mr. Ephraim, since co-counsel introduced you, I'm happy with that being the introduction, unless you want to separately introduce yourself.
No need, Your Honor.
That'll work. Thank you very much. Let me just very quickly check with our scoring panelists. Are all of you ready to begin the trial?
Good to go.
Yes, Your Honor. All set.
Thank you very much. In that case, we'll now hear opening statements from each party. Everyone, please make sure that you're in speaker view, and then that button is on the upper right of your screen. And attorneys, please remember to mute your audio when the other attorney is speaking. And also, if you're not one of the attorneys participating in the particular function, such as opening or the direct or the cross, we ask that you deactivate your videos during those times as well. We'll begin with opening statements, starting with the state's opening statement. When you're ready, you may proceed.
Your Honor, if it would be all right with the court, we would like to.
I'm sorry. The ironic thing is, Mr. Symbol, I told you I wouldn't skip those things, and what did I do? I skipped those things. I think you jinxed me with that. My apologies. We need to start with housekeeping matters as well as motions in limine. Let me begin with housekeeping matters on behalf of the state.
Thank you, Your Honor. Given the unique rules of this jurisdiction, we'd like to know if we could have deem all mid-trial objections constructively at sidebar.
I think that's a good approach. Unless there's an objection by the defense, we'll presume that conversations regarding objections would be at the bench constructively.
No objection, Your Honor.
Thank you, Your Honor. And secondly, when seeking to introduce evidence such as photos or reports, may we share our screen with the witness for the purpose of laying foundation, again, constructively outside of the presence of the jury?
My preference would be that they're able to use the electronic copy that they have, but I don't have an objection. If it's easier for you to share the screen so that they can see that to lay the foundation, what we presume is that until the exhibit is admitted, the court could see it, counsel could see it, and the witness could see it, but it would not be published to the jury at that time. So either approach would work, and I leave that to your discretion.
Thank you, Your Honor. With that, we are ready to proceed to our motions in limine.
All right. First, were there any additional housekeeping or preliminary matters by the defense?
Yes, Your Honor. We are dealing with expert witnesses, and for the federal rules of evidence, I would like to a clarification from this particular court on whether or not you want us to formally tender our witnesses as experts in their particular fields.
That's my preference. That avoids the difficulty in determining if we've crossed that threshold and we've met the 702 requirements. And I know that varies between jurisdictions, but my preference would be that we formally tender them and accept them before they give opinion testimony.
No other housekeeping matters, Your Honor.
All right, in that case, let's move to motions in limine, beginning with the state. Any motions in limine on behalf of the prosecution?
Yes, Your Honor. Before I begin, would you like a brief recitation of the facts?
I'm aware of the facts, but usually I find that outline helps in understanding the basis of the motion. So I'll let you go ahead with that if you'd like to begin with a brief summary of the facts as well.
Yes, Your Honor. The prosecution has charged the defendant with one count of first-degree murder. On October 17th, 2018, the defendant was working on his laptop when his 6-year-old son, Nathan, was having breakfast. Nathan accidentally spilled his juice on the defendant's laptop, which destroyed it. The defendant then proceeded to abuse his son through a series of torturous actions, ultimately resulting in the strangulation of Nathan. That being said, the defendant has claimed insanity and that he was dealing with schizophrenia on that particular event. That has now become one of the main issues at trial today. And with that, we have a good faith belief that the defense would like to admit statements regarding the defendant's childhood trauma and family history that would be obtained by Dr. Riley during his interview with the defendant's father on page 62, 65, and 66. We move to exclude this childhood trauma and family history on the basis of relevance FRE 401 and unfair prejudice FRE 403.
Defense response.
Yes, Your Honor. We object to this motion. We feel that it would be improper. For expert testimony, Rule 703 is in place. Therefore, when this information is brought up, we have not laid the predicate foundation or the requisite connection between Dr. Riley's prognosis of Mr. Ray and Dr. Riley's discussion of family history and how that relates, then an objection at that time can be made, but this information will be shown to be relevant because Dr. Riley will testify to how hereditary factors and childhood traumas relate to a diagnosis. And so 703 is the bar that we must meet.
Help me a little with the relevance at this point, since that could affect the ruling in limine. In what way is it relevant, or what material fact does it make more likely to be true? I think I may know, but so it's expressed, go ahead.
Yes, Dr. Riley, and just to confirm, we are outside the presence of the jury at this time.
Correct. We presume that matters in limine would absolutely be outside the presence of the jury. That's a fair assumption.
Yes. So Dr. Riley will testify to the research that he cites in his report that if a family member, a parent, has schizophrenia or severe mental illness, it can increase the likelihood up to tenfold that their offspring would suffer from such.
All right. That assists. I appreciate that. Let me go back to Mr. Simbal. Any reply?
Yes, Your Honor. As for relevance, both experts will be relying upon the universally accepted guide of the DSM-5. The DSM-5, as is within the name, relies upon 5 core symptoms to diagnose a patient with something, mental illness like schizophrenia. That being said, the DSM-5 has no mention whatsoever of childhood trauma or family history. And for that reason, while it may even be a slightly contributing factor, it's not mentioned within the guide that doctors use to diagnose patients. Furthermore, as for prejudice, this information regarding the defendant's alleged neglected childhood by his mother will serve to inflame the passions of the jury with pity for the defendant, and therefore it would not survive the reverse 403 balancing test contained within FRE 703, which would require that it would be substantially more probative than prejudicial, and it does not pass that test.
I usually don't go back and forth, but since it's identified a specific issue in terms of the DSM-5 criteria, I want to come back to Mr. Ephraim. The argument is that that background is not one of the criteria, so therefore it wouldn't be relevant to the opinion. Any response?
While not a required criteria, it is discussed as a causational, let me rephrase, Your Honor. The family history of Mr. Ray is, while not directly mentioned in the DSM-5 as part of the diagnosis, Dr. Riley lays the foundation during his direct that the family history is in fact relevant to a diagnosis of schizophrenia, which is why at the time of the direct, it would be appropriate to return to this if opposing counsel sees fit.
Ultimately, where I think I stand at this point is it sounds to me like it's an area that's best addressed through cross-examination, possibly a contemporaneous objection. So certainly the state can remake the objection, but it may be through cross-examination. And so I don't think there's a risk of somehow tainting the jury in that regard. So I decline to grant the motion in limine in advance of the trial. But Mr. Simbal, you're free to re-raise the objection at the time contemporaneously or to address it through cross-examination in terms of the conflict between the testimony and the DSM. With that, though, is there any additional objection by the, motion in limine by the prosecution?
Yes, Your Honor.
Go ahead, Ms. Jackson.
Thank you. We expect the defense to present testimony through their expert, Dr. Riley, regarding a statement given to them by Officer Cruz regarding the defendant's mental competency. The statement goes as follows. The patient was seen sleepwalking and seeing things for 1 month. This statement is located in Exhibit 9 of Dr. Riley's psychiatric evaluation in 2010. We are moving to exclude this statement as hearsay pursuant to 801.
For the defense, your response is to hearsay.
Yes, Your Honor. This was a statement made to Dr. Riley at the time for a medical diagnosis and falls under the hearsay exception for such. 804, I'm sorry, is it 804.3? 804.
Ms. Jackson, your position in terms of 803.4?
Yes.
Your Honor, we believe that this statement does not survive the 703 analysis. It's substantially prejudicial to the probative value because the statement is provided to Dr. Riley through an officer from 2010 who the expert actually deemed as a liar, therefore suggesting that this officer is non-trustworthy.
Your Honor, that's a mischaracterization, if I may respond.
Actually, before we come to that, I wanted to follow up on one point. Ms. Jackson, you mentioned it was Rule 703, which would only come into play if the information was otherwise inadmissible. If it falls into the exception or 803.4, it wouldn't be otherwise inadmissible. Is there a position you have as to why this would not fall under 803.4?
No, not at this time, Your Honor.
And that may have, Mr. Jeffrey, that may have been where you're going, but let me come back to you. You had an additional reply. Go ahead.
Just the statement that Officer Cruz is I believe she called him a liar outright. There's nothing in the record that reflects that he's an outright liar, simply that he exaggerates the truth from time to time.
I appreciate the argument on both sides. I think you've touched on a number of the relevant rules that have to be weighed and addressed. Certainly the question of the credibility issue and how that's described can come out through the testimony. Under Rule 703, otherwise inadmissible evidence may not be brought in under the proponent or by the proponent unless we do that, essentially what everyone calls the reverse 403 analysis. But given the position that under 803.4, statements for purposes of medical diagnosis are not limited to the person receiving the treatment necessarily, given these circumstances, I will overrule the objection in limine and let you proceed with that. I think it's well argued, but I'm going to go ahead and overrule the motion. Any additional motions in limine by the state at this time?
No, Your Honor.
Actually, sorry, Your Honor, there's one more thing.
Yes, Mr. Simbal, go ahead.
Thank you, Your Honor. We did meet and confer with opposing counsels, and they did state that they would have an objection to at least one, if not both, exhibits that we intend to use during our opening statement and other statements.
That is absolutely something we should address in limine. I just want to make sure I'm hearing you, Mr. Zimbo. It sounds like you're planning to display certain anticipated exhibits during the opening. Is that correct?
That's correct, Your Honor.
All right. And I guess on a certain level, if the defense is objecting, that should probably come in through their motions in limine in advance, but I appreciate the advance notice. I'll turn this over to the defense. Any motions in limine by the defense?
No motions in limine.
And let me go to that area
Your
so
Honor,
we
I
can
apologize.
avoid that conflict. Oh, go ahead.
Your Honor, we motion that the prosecution not be allowed to enter those two exhibits on their opening statement. We believe that there is a good faith understanding that those could reasonably be objected to and excluded, and we don't want to prejudice the jury with exhibits that may not come in.
And at this point, no, and that's about position. At what page in the electronic case file do we have are the exhibits that are contested?
I'll find the exhibit numbers, but the exhibits are 21 and 29.
Right. I may be able to scroll to those.
Yeah, it should be toward the very end.
Well, I understand it.
29 being that, I believe my understanding from our pretrial proceedings, the picture of Nathan Ray, and 21 being the photograph of one of the baggies at the scene. Let me go ahead and let the defense, if you could explain a little more for the basis why you think that those would not be admissible, and we can address that at this point.
Your Honor, I believe that those specific exhibits are going to be more prejudicial than probative at this time under Rule 403.
All right. For the state, excuse me, I'm used to saying people. For the state, your position as to why those would be admissible.
Yes, Your Honor. As for the first photograph, which would be that of Nathan Ray, Exhibit 29, that photograph is the very definition of malice, which is what we as a prosecution are tasked to prove in proving the charge of first-degree murder against the defendant. This photograph will show for the jury who the defendant looked in the eye as he continued to strangle. This will show the jury that he acted with intention against a 3'9", 45-pound child. This will help them put a face to the victim and ultimately will provide narrative integrity as for that exhibit. If Your Honor would like, I can proceed to Exhibit 21.
It's probably easy to address them both at the same time. I think there's overlap. Go ahead.
Well, I would just add for Exhibit 21, this is a separate photograph of Nathan, of course, when he was deceased already. And at this point, in this photograph, there is no indication whatsoever of body parts, limbs, blood, or anything that would inflame the passions of the jury and prove to be prejudicial. The jury does need to see what exactly happened with the victim and how that actually is reflected in the defendant's searches in his phone, which we'll raise up later in trial today. And they correspond to what he did after the killing and thus show his intent to get rid of the evidence and thus maliciously kill and hide the fact that he murdered his son.
Mr. Allison, your response.
Yes, Your Honor. Without the context of how they're going to bring this up in their direct examination and how they plan on presenting these exhibits, it's unclear whether or not these will be more prejudicial, and we would still than probative, and we would still object at this time that they are going to be more prejudicial than probative.
I appreciate the position. What I'll find at this point, and I'm glad it's been raised, generally in opening statements, the party who's bringing in evidence that they have a good faith basis to believe would be admitted. There's certainly the risk if that doesn't come in falls on that party. Photographs are often different in that regard because it's hard for a jury to unsee a photograph and it has an impact. Nevertheless, given the nature of these particular proceedings, I think there's a good faith basis that they would come in. I'm very confident that this jury would be able to disregard evidence that was not admitted. There would not be unfair prejudice if that was the case. And so I might rule differently in a real trial, but for today's proceedings, I'm going to overrule the objection to the use of these in the opening statements. I would allow it for that purpose, obviously at the risk of the prosecution that if the evidence doesn't come in, we'd have to instruct the jury to disregard them. Any additional motions eliminated by the defense at this time?
No, Your Honor.
Your Honor, I just ask that I retain the ability to object on relevance grounds during the opening if they leave these photos up beyond the scope of what their discussion is during the open regarding them.
That's a different issue, absolutely. I would not require you to re-object to preserve it. I think you've preserved the issue in terms of the 403 issue, but I would agree, for instance, if it's simply being used for a lengthy period of time, or it's being used in a way that would basically inflame the passions of the jury beyond the content, you could make that objection at that time. So you have preserved the ability to make that objection.
Thank you, Your Honor. Nothing further.
Thank you. With that then, let's now that I'm finally back on track where I'm supposed to be, let's go ahead and move on to the opening statements, beginning with the state's opening statements. When you're ready, you may proceed.
The greatest trick the devil ever pulled was trying to convince the world that he didn't exist. On October 17th, 2018, the defendant strangled and killed his son. After abusing Nathan Ray, the defendant decided to grab his belt, wrap it around his son's neck, and squeeze the life out of him. Good afternoon. My name is Kendra Jackson, and on behalf of my co-counsel, we represent the state of West Carolina. As a result of the defendant's actions on October 17, 2018, the defendant has been charged with 1 degree of first-degree murder. It was an ordinary day for Nathan Ray. He got up from his bed, headed to the kitchen to have breakfast with his dad. He was having his favorite breakfast, Frosted Flakes, when he accidentally knocked over his juice and spilled it all over the defendant's laptop. The defendant became furious. A man whose wife was having an affair, who was in the midst of a divorce, decided that Nathan needed to be punished. He forced Nathan to do extraneous exercises, jumping jacks and high knees exercises. He yelled at Nathan so much so that Nathan ran to his room crying. And even after the accident, after the exercises, Nathan wouldn't stop crying. He wouldn't do the exercises. He would not listen. So the defendant left Nathan's bedroom, went down the hall into his own room, sat to calm down and reflect. And that's when the defendant grabbed the belt and headed to his sobbing son in the next room. In that room, the defendant whipped his son. Nathan's screams grew louder. The defendant then wrapped that belt around Nathan's tear-soaked neck and pulled tight. The defendant, at 6'2", 180 pounds, towered over Nathan's 45-pound body. Nathan looking up at his father as his father squeezed the life out of him. That didn't stop the defendant. Not after squeezing the life out of his son, not after trying to get away with murder. The defendant then took Nathan's lifeless body and put it in a trash bag and dumped it in a swamp. Now fast forward to 2 days later, when the defendant came into contact with Officer Wentz, who saw suspicious items in the back of the defendant's car. trash bags, jugs of bleach. And this is important because a later search of the defendant's phone will show you that he searched how to get rid of a body for countries that don't extradite for murder. And listen to this. Will bleach destroy a body? Later, after he was arrested, the defendant confessed to Detective Booth that he murdered his son. Now I anticipate the defense is going to come up here and they're going to claim that the defendant was suffering from schizophrenia, that he was in the midst of an episode when he strangled his son to death. But that's not true. And you don't have to take my word for it. We're going to call an expert, Dr. LaGreca, a board-certified forensic psychiatrist who has decades of experience. And he will tell you that the only thing the defendant was suffering from was a mild case of malingering. He was faking it. Dr. LaGreca will even tell you how he exaggerated symptoms. Symptoms like hearing voices and seeing cameras in a microwave. Symptoms he's never even told a soul about. Not until he was caught red-handed for the murder of his only child. But that won't stop the defense from trying to convince you otherwise by presenting Dr. Riley, who, when hearing his testimony, keep in mind that Dr. Riley is the only doctor who believes that the defendant was suffering from schizophrenia. No, not Dr. LaGreca, not his primary care physician, not the jail psychiatric doctor, not even Dr. Riley himself, who evaluated the defendant in 2010. In fact, Dr. Riley will be forced to admit, given the facts, that not even he can rule out that the defendant is faking it. And that's why at the end of this trial, my co-counsel will stand before you, having reviewed all of the evidence. He will ask you not to fall for the defendant's misdirection. Mental illness didn't kill Nathan. The defendant did. And no matter how much bleach the defendant will use to wash away his wrongs, it will not wash away the truth. Find the defendant guilty.
Ms. Jackson, thank you very much. We're ready to proceed to opening statement by the defense. Mr. Ephraim, are you ready to proceed?
Yes, Your Honor. Eileen Sachs wrote that the schizophrenic mind is not so much split as shattered. It's like a waking nightmare. My name is Alex Ephraim. My co-counsel is Trey Allison, and the onus is on us to show, using clear and convincing evidence, that Mr. Ray is not guilty by reason of insanity. Mr. Ray first heard voices that no one else could at the age of 10, brought on by his schizophrenia. Triggered by the fear and isolation that came from his mother's abandonment, he would fight these voices, his schizophrenia, periodically. He would deny his illness, but his schizophrenia progressed. The voices dictated more of his reality until he no longer knew right or wrong. Mr. Ray committed this heinous act. However, by the letter of the law, one must find the defendant is not guilty by reason of insanity if they find the following three statements met by clear and convincing evidence. First, that Mr. Ray suffers from severe schizophrenia. Second, that he was insane at the time his son died. And third, that due to his schizophrenia, he could not tell the difference between right and wrong or appreciate the wrongness of his acts the morning of October 17th. Mr. Ray is sick. He's been sick for a long time now. Ladies and gentlemen, his schizophrenia progressed. The voices dictated more of his reality until he no longer knew right or wrong. You're going to hear today from prosecution's witness, Dr. LaGreca. The facts are going to show, however, that Dr. LaGreca's assessment is wholly inconsistent with the record. The fact is, Dr. LaGreca's assessment was made without ever once speaking with Mr. Ray or any of his family or associates, and is based primarily on secondhand knowledge gathered from Dr. Riley's report. You're going to hear from Dr. Riley, though, who's actually sat down with Mr. Ray to let us know what is happening inside his head. What happened is his schizophrenia progressed. The voices dictated more of his reality until he no longer knew right from wrong. Both experts are going to discuss the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, commonly referred to as the DSM-5. The DSM-5 outlines the process of diagnosing someone with schizophrenia, and Dr. Riley discusses the process of diagnosing Mr. Ray along the DSM-5. He's going to explain how Mr. Ray was suffering from delusions, hallucinations, and negative symptoms. And as part of the process of diagnosing someone with schizophrenia, Dr. Riley discusses possible disturbances that could have triggered psychotic episodes in Mr. Ray's life. And finally, Dr. Riley discusses whether or not the defendant had an underlying drug problem or underlying medical condition as the final part of making his diagnosis. You're going to hear from Officer Wentz today. Officer Wentz is the first person that came in contact with Mr. Ray after the death of Nathan. He's going to discuss the negative symptoms of Mr. Ray's mental disorder, such as his disheveled clothes, the stains on his shirt, his strong body odor. He's going to tell you that Mr. Ray could hear CIA sirens, that he asked if he was in the CIA, that he was erratic, that he was frantic. That is when Officer Wentz's crisis intervention training kicked in, and he thought Mr. Ray was exhibiting signs of mental distress severe enough that he required medical assistance. Dr. Riley is going to talk about his first interaction with Mr. Ray back in 2010, when he was part of a small team overseeing 20,000 troops to determine frontline readiness. Mr. Ray's commanding officer had brought him in because he had caught him hallucinating, seeing things that were not there. He was diagnosed with a general anxiety disorder and told to seek further help, and discharged by Dr. Riley. Dr. Riley is going to discuss how in 2015, Mr. Ray's paranoias shifted towards his marriage. His auditory hallucinations, his schizophrenia, began pushing the idea that his wife was cheating. Mr. Ray's ex-wife, Jessica Ray, described him as always having issues with mood swings, a similar description that Abe Ray has of Mr. Ray's mother. She describes Mr. Ray over the course of their marriage as becoming more and more isolated. He would lock himself in the bathroom for hours and refuse to come out and go a week or more without showering. Then around 2017, she describes that Mr. Ray became a completely different person. Negative symptoms, hallucinations, delusions. His schizophrenia was progressing. The voices were dictating more of his reality, and soon he would no longer know right from wrong. During Dr. Riley's testimony, he also separates violent and nonviolent schizophrenics. You're going to learn that in early 2018, Mr. Ray slammed a fellow employee against a wall at work and threatened their life. But Mr. Ray did not get in serious trouble, when perhaps he should have, because he needed serious help. Finally, Dr. Riley discusses whether or not someone suffering from severe schizophrenia is able to distinguish right and wrong. This is what brings us to the morning of October 17th. Mr. Ray is struggling with the voices inside his head, his schizophrenia. First, he was cheated on, and now his wife was turning his son against him. The voices knew about the affair. They know about Jessica and Nathan. That morning, Nathan even tells him that he hates him, that he wants to go to his mom. Mr. Ray went back to his room and he tried to fight. But he grabbed that belt and he strangled his son. He would drive around with Nathan's body for 2 days before putting him in a bag and burying him in a shallow grave. He thought that the CIA was after him, not standard law enforcement, the CIA. He thought Officer Wentz was CIA. He thought Detective Booth was CIA. He even thought that Dr. Riley had a CIA camera in his microwave during the only time he has spent with a forensic psychiatrist since his arrest. It will become clear to you, Mr. Ray suffers from schizophrenia. It will become clear to you that Mr. Ray is violent. It will become clear to you. There is convincing evidence that Mr. Ray could not appreciate the difference between right or wrong, or the wrongness of his acts the morning of October 17th. Mr. Ray is the person that we have to hold accountable, but by the letter of the law, we must hold him accountable in the right way, which is why my co-counsel and I are going to ask that you return a verdict of not guilty by reason of insanity later on. Thank you.
Mr. Ephraim, thank you very much. In that case, we're going to go to the next phase of the trial, which is the presentation of the evidence, beginning with the the state's case in chief. At this point, though, I'd encourage all of our participants, and especially our scoring panelists, to go ahead and switch to gallery view, which is the button in the upper right-hand corner of the screen, so that you can see the attorneys and witnesses at the same time. I'll do that now. And with that, then, I will go ahead and turn this over to the state, and the state may call its first witness.
Yes, Your Honor. The prosecution calls Detective Booth to the stand.
Detective Booth will presume that you've been constructively sworn in as a witness. If I could have you begin by stating and spelling your name, please.
Detective Blake Booth, Booth B-O-O-T-H.
With that, then, Mr. Simba, when you're ready, you may inquire.
Thank you, Your Honor. Good afternoon, Detective Booth.
Good afternoon.
What do you do for a living?
I'm a detective with the Skelton Police Department. I've been with the force for about 23 years now, and I currently work for the homicide unit, which is how I got involved in this case.
I'd like to ask you more about how you became involved. How did you become involved in the investigation on October 19th, 2018?
Well, I received a call that Officer Wentz had stopped Timothy Ray, who was the father and the suspect in the murder of Nathan Ray, and they were at a sobriety checkpoint. I arrived and Mr. Ray was actually handcuffed on the side of the road.
What did you do next?
Well, I went over to Mr. Ray and I told him that we would need to take him in to answer some questions at the station. And we left shortly after that.
At this point in time, did the defendant ask you anything or say anything at all about the CIA?
No, he did not.
Did he say anything at all about whether or not he understood what was going on?
He did. Actually, Mr. Ray said, I understand, I'll tell you everything. And the way that he said it, I believed him.
Direct your attention now to your interaction with the defendant at the police station. During this interview, did the defendant say anything about the CIA at that point?
Yes, at that point he did. He specifically asked me if I was with the CIA, but I reminded him that I was not and that I was a detective with the Skelton Police Force.
Was the defendant's confession recorded?
It was, and it was also preserved by transcript. I preserved that transcript, but I did not reserve the audio or the video of the recording. That automatically is erased in our system after 30 days.
Let's talk more about the defendant's confession. What information did you gather from the defendant's interview?
Mr. Ray confessed to killing his son Nathan and to burying Nathan's body.
What was the defendant's demeanor like when he was describing killing his son?
Well, given that he was discussing killing his only son, he was visibly upset.
According to the defendant, what exactly happened on October 17th, 2018?
Mr. Ray said that he was getting ready to go to work and his son Nathan sat down to have breakfast.
Was this happening in Skelton County?
It was.
Referring court and counsel to what has been pre-marked as People's Exhibit 29 for identification, Your Honor, permission to publish constructively outside of the presence of the jury? I can't hear you, Your Honor.
Oh, sorry. Can you make sure that's to the witness? Yes.
Thank you, Your Honor. Detective Booth, do you recognize this photograph?
I do.
How do you recognize it?
That's a photo that Jessica Ray, Nathan's mother, provided to us when she submitted his missing child report.
And what is this a photograph of?
It's a photo of Nathan himself.
Is this a fair and accurate portrayal of Nathan when he was alive in October 2018?
Yes, it is.
Now, the people move prosecution exhibit 29 into evidence.
Any additional objection by the defense?
This is a smiling photo of Nathan and is more inflammatory than probative. And Your Honor, we discussed this in the meeting, so I understand if you would like to move on.
Given that, though, I think it's appropriate to address it at the time. Mr. Simbal, any additional argument you had at this point?
Sure, Your Honor. In regards to unfair prejudice and relevance, this photograph, as you mentioned earlier, is relevant in that it is the very face of the victim in this case. And as for unfair prejudice, the unfair prejudice must substantially outweigh the probative value posed by the photograph. The defense has not stated how this photograph is substantially outweighed by its probative value. For that reason, the fact that, again, it goes towards the element that we as a prosecution have the burden of proving, that being malice, its probative value outweighs its prejudice.
Appreciate it. As a general observation, unlike a photograph of the defendant where we have to establish identity, I don't know that a photograph of the victim, although we have to show that someone is deceased, I don't know that this actually lends to that determination. Traditionally, however, as long as it's not exceptional, it's not overdone, most courts will allow at least a single photograph of the victim under the circumstances. It's the proper objection, but I'm going to overrule again, persist in the earlier ruling. Exhibit 29 is admitted over objection. With that, the state may continue.
Detective Booth, you had mentioned that Nathan was eating breakfast. What was he eating that day?
Nathan was eating a bowl of his favorite cereal, Frosted Flakes. He was also drinking a apple juice.
And what happened next?
Nathan accidentally knocked over that glass of apple juice and it spilled onto Mr. Ray's laptop. Mr. Ray tried to turn the laptop back on, but found that it was fried.
How did the defendant react to realizing his defendant was inoperable?
He said that he needed to punish Nathan for spilling the juice and for what he had done. So he started to yell at the boy, and then Nathan got upset and he ran off to his room.
What did the defendant decide to do next?
Mr. Ray actually followed Nathan into his room and he continued to yell at him. It was at that point that he decided that he would make Nathan do physical exercises, including jumping jacks and high knee exercises. Nathan wouldn't stop crying, and eventually he had to stop doing the exercises. He just couldn't go on.
How did the defendant react to Nathan's inability to continue?
Mr. Ray apparently decided that he needed to punish Nathan some more. He wanted to make him understand. So he went into his bedroom and he took a few moments before he grabbed a belt from his closet.
Detective Booth, what did he do with that belt?
Well, Mr. Ray took the belt and then he decided to go back into Nathan's room. It was there that he hit Nathan with the belt a few times on his bottom. Nathan began to cry even more and he was screaming. He specifically called out for his mother, but at that time, Jessica Ray and Mr. Ray, they were no longer living together. Nathan also yelled out that he hated his father.
What eventually happened to Nathan?
Well, the defendant decided to put the belt around his neck. He began pulling on the belt, so it was getting tighter and tighter around Nathan's neck, and Nathan was struggling to breathe. In fact, Mr. Ray held it there so long, Nathan couldn't even scream, and then the defendant strangled Nathan to death with the belt.
Objection.
Is the basis of the objection? I'm sorry, the basis of the objection?
This assumes facts, not evidence.
Any response?
Your Honor, everything that the detective is testifying to is exactly what he heard directly from the defendant himself as to what happened on October 17th, 2018.
At no point does the defendant, opposing counsel, I apologize if I cut you off. Please finish.
Go ahead.
I do not recall anywhere in the interview Mr. Ray saying that he pulled so tight to the point where Nathan, as she put it, was unable to scream at all at any point. Is it, did I hear that correctly? I apologize if I did not, Detective Booth.
Well, that's all right. It assists me with the argument. What I'm going to find at this point is I agree. An assumption of facts, not evidence, generally applies to the question. The testimony itself is the evidence. If it's inconsistent with the prior statement, I'd let that be an issue on cross-examination and impeachment. So I'll overrule on that basis and let you ask the next question.
Yes, Your Honor. Detective Booth, what ultimately happened to Nathan?
The defendant strangled him to death with the belt.
And in investigating this killing, did you ever search the defendant's belongings?
Yes, we did, and it was during that search that we searched Mr. Ray's phone. We found 3 searches within the phone that became relevant to our investigation.
What were the 3 searches?
Objection, Your Honor.
Go ahead. The basis of that objection.
This line of questioning lacks foundation. I understand that it is stipulated that it is Mr. Ray's phone, but the question asked, what did he search? And they have not laid the foundation that he searched these searches that the prosecution is about to bring up.
I'll take it as an objection to Rule 612 in terms of foundation of personal knowledge. Mr. Simbal, your response as to Detective Booth.
The question that I asked Detective Booth, which prompted her to respond that there were 3 searches found in the phone, was whether or not she conducted any search of the defendant's belongings. That lays the foundation that the detective proceeded in her investigation to ultimately search the defendant's belongings, one of which the items were the phone itself. So I believe the detective has laid sufficient foundation for how she had obtained those searches.
Any response, Mr. Ephraim, by the defense?
Again, Your Honor, the phone belonging to Mr. Ray is not at issue. I simply would like more foundation as to the fact that Mr. Ray is the one that made the searches before actually discussing what was searched, which is what I objected to. That was the question I wanted to object preemptorily to.
At this point, I think if I'm understanding the objection, I would sustain without further foundation as to who had conducted the searches, or if Detective Booth was the one, or if not, how she had knowledge of that information. You may have touched on that, and I may have misheard it, but in any event, I would sustain as to her going into it, searched without the foundation as to who had done the searches or how she had knowledge of that fact. If I'll let you rephrase the question, lay additional foundation, you can proceed.
Detective Booth, was there any circumstantial evidence that pointed to the fact that those searches were made by the defendant himself?
Yes, the searches were found on Mr. Ray's phone in the exhibits that we provided as well. It specifically says Timothy Ray's iPhone, so we knew that it was.
And my apologies, I think I was misleading in my ruling. As my understanding is that the police searched the phone. I don't know out of the police who searched the phone to find the internet searches, and I shouldn't have used the word search twice. The basis for the detective, if the detective searched the phone, or if some other police officer did. So, Mr. Simbal, my apologies, but I'll let you lay foundation as to that fact.
Yes, Your Honor. Detective Booth, who exactly obtained those searches on that phone?
The search was made by members of the Skelton Police Department.
And were you a part of the team that investigated the defendant's belongings?
Yes, I was. I was the lead detective on that.
So, Detective, did you happen to see the searches yourself personally as well?
I did.
And what were those 3 searches?
There were 3 of them, as you mentioned. The first was the first was countries that don't extradite for murder charges. The second was how to get rid of a body. And the third was, will bleach destroy a body?
Thank you, Detective Booth. What ultimately did the defendant do after he strangled his son?
He placed Nathan's body in a large trash bag, and then he buried his son in a shallow grave inside the Brandywine State Park.
Referring court counsel to what has been pre-marked as People's Exhibit 21 for identification. Your Honor, permission to publish constructively outside the presence of the jury?
You may show it to the witness, yes.
Thank you, Your Honor. Detective Booth, do you recognize this photograph?
I do.
How do you recognize it?
My forensics team photographed and processed the scene that we've discovered this bag in at the Brandywine State Park.
And what is this a photograph of?
It's a photo of Nathan's body, which is the black trash bag. This was buried in a shallow grave at the park, and you can actually see Nathan's shoe on the left-hand side of the image.
Is this a fair and accurate portrayal of the crime scene as you found it in your investigation?
Yes, it is.
Your Honor, at this time, the people move Exhibit 21 for identification into evidence.
Any additional objection by the defense to Exhibit 21?
No additional objections, Your Honor.
I'll persist in the prior ruling. It was in limine. I think the probative value is arguably not significant, but I think the risk of unfair prejudice doesn't substantially outweigh that. Exhibit 21 is admitted over the prior objection. You may proceed.
Understood, Your Honor. Detective Booth, do you see who did that to Nathan?
Yes, I do.
Could you please point them out in the Zoom call?
He's sitting on the Zoom call beside counsel.
Let the record reflect that Detective Booth has identified the defendant.
I think she may have identified me the way it's laid out on my screen, but at this point, for purposes of today's proceeding, subject to cross-examination, I'll find that the detective has described the defendant, and you may proceed.
No further questions. Thank you, Your Honor.
Thank you. Any cross-examination?
Yes, Your Honor. Officer Booth, appreciate your time today. You went to the academy, do I have this right, 23 years ago?
That's correct.
And you had specific training in recognizing mental distress or some sort of mental health training?
When I first entered the academy, yes.
But you don't recall anything from that training?
Not the specifics, no.
Detective, you went to some sort of training or educational program when you became a detective, some investigative school?
Yes, I received additional training at that time.
And you've now worked 12 cases as an investigator?
Yes, and this is my fourth time being the lead investigator.
So Nathan's is the fourth time you've been lead?
That's correct.
Okay. Officer Booth, or I'm sorry, Detective Booth, I apologize. I'd like to discuss your interaction with Officer Wentz that night that you went out to the checkpoint. Did you speak with Officer Wentz that night as part of your investigation?
Yes, I did.
Is this a standard practice to speak with the officer on site?
It is.
Officer Wentz told you of his observations of Mr. Ray?
At that time, yes, he did.
Officer Wentz described him as having a strong body odor?
He did.
That Mr. Ray looked disheveled?
I believe that's what he said, yes.
And he let you know that when he radioed in that Mr. Ray was acting crazy?
Yes, I believe that was what he said.
That night, did Officer Wentz suggest that Mr. Ray need medical assistance?
I'm not sure as to whether he suggested that to me. I know that no paramedics were called to the scene, so we took Mr. Ray in for questioning.
Outside the scope of direct examination.
Your response?
Your Honor, I am asking about Officer Booth's direct interactions with Officer Wentz as part of their investigation. At this point, this is the first interaction with the defendant and the arresting officer and shaped the investigation from the beginning point here.
Let me ask, the objection was though that it was outside the scope of the direct under Rule 611C. Why would it be admissible at this point?
Because it goes directly to Officer Booth's investigation of Mr. Ray.
And how does that make it fall within the scope of the direct?
As we heard on direct, Officer Booth discussed his interaction with Officer Wentz that night, as well as his interaction with Mr. Ray at the precinct.
Mr. Timbo, your response.
Detective Booth have made no mention during direct examination of any call for an EMT or any expectation of an EMT. For that reason, what opposing counsel is asking for is outside the scope of the direct examination.
Ultimately, under Rule 611, it does have to fall within the scope. There can be exceptions to that. I think this touches on an area in terms of the discussions, the interaction between the police and the defendant. So although it doesn't go to a particular conversation, it does go to the subject matter of the direct. I'm going to overrule. Is outside the scope. You may continue.
Did you ask Officer Wentz if there were any sign of physical abuse or substance abuse?
I believe, yes, I did ask him that.
And it's true that Officer Wentz did not report any sign of substance abuse or any physical injuries to Mr. Ray at that time?
That's correct.
Let's move forward, Detective Booth, to your interactions with Mr. Ray. You interviewed Mr. Ray,
I did.
and you thought Mr. Ray understood what was happening during your interview?
Yes, he had told me previously that he understood what was happening.
You can't really explain why, though?
Other than him explicitly stating that he understood, it was just my observations as an experienced detective.
Okay. Detective, you were part of a preliminary hearing today, or before today? Is that right? And you testified at this preliminary hearing? I have you turn to Exhibit 1 for me, page 29. Opposing counsel, have you do the same. And please let me know if I've read this correctly. I'm going to be reading from lines 11 through 15. Question, did you have any reason to believe, based on your observations of the defendant, that the defendant did not understand what was happening during the interview? Answer, no. Based on what I observed, I believe the defendant understood what was happening. Question, why? Answer, I can't really explain it. I could just tell. Did I read that correctly?
That's correct. I could just tell, given my experience.
Objection, Your Honor, improper impeachment.
Specifically, what aspect did you believe was improper?
Your Honor, the fact that the detective explained they were able to understand, that the defendant was able to understand them based on other aspects of this very same report, such as the fact, as the detective had explicitly stated, the defendant told her that he understood everything that was going on. So her referring to that portion of this report does not therefore impeach her because it's a logical inference to that particular statement.
Let me come back specifically. How was the testimony inconsistent with the portion of the transcript that was read from the defense?
Is that a question for me, Your Honor?
I'm sorry, for the defense. So for Mr. Ephraim, your position, how do you believe the question beforehand or the answer beforehand was inconsistent with the deposition testimony?
Well, they extrapolated past, I could just tell, and I can't really explain it. And I thought that that was a different enough, an inconsistent statement with what I just read. So I wanted to clarify for Officer Booth, and just so the court and the trier of fact may have a better understanding of whether or not they were able to explain why.
And at the time, what was your recollection of the answer that you thought had gone beyond, I can't really explain it, I could just tell?
Yes, that was my understanding, is that the answer went just slightly beyond that.
And then what, as I'm saying, I don't recall the testimony. What was it that you believe the witness said?
That they are, Detective Booth, I believe, just testified that they were able to make these determinations based on their interactions with the defendant. And I just wanted to clarify that the difference in their statements during the preliminary hearing compared to today.
And Mr. Simbal, any reply?
Yes, Your Honor. The detective was referring to a statement made elsewhere in the report that complements this particular statement. While at that time, the detective may not have been able to say exactly how they came to the understanding that the defendant understood her, there was other evidence the detective observed, which she has already mentioned on the stand, that helped her come to the conclusion she arrived at. And the reason picking and choosing one statement that is complemented by another one, which the detective has properly referenced, is an improper impeachment.
What I'm going to find at this point, or what I'll rule, is twofold. Certainly, impeachment has to be inconsistent, otherwise it's simply bringing out hearsay. Ultimately, in this situation, I'll find that that's an issue for the jury to decide if it was inconsistent or whether or not they think it impeaches the witness's credibility. And as to the differences, rather than finding it's improper impeachment, I presume we could either address under the rule of completeness to read the portion that should come into this time, or allow it to be a subject matter on direct to clarify that other portions were in fact consistent. That's a way of saying I'm going to overrule the objection, or the objection, and I'll turn this back over to Mr. Ephraim. You can continue.
Thank you, Your Honor. Detective Booth, at any point did in your interview with Mr. Ray, did he ask if you were from or with the CIA?
Yes, he asked me if I was with the CIA, and I told him no, that I was a detective with the Skelton Police Department.
Did he ask if you were from or with the CIA when you handed him the waiver of rights form?
I believe that he may have asked me that, and I clarified with him that I was not.
Did he say at some point in your interview that she tricked him to spill the juice?
Yes, he did.
Did Mr. Ray say that they told me she tricked him?
He did.
Mr. Ray put a belt around Nathan's neck because Nathan had to understand. Do I have that correct?
Yes.
Mr. Ray said they told him to make Nathan understand.
I believe that's what he said, yes.
Objection, hearsay.
Responses to hearsay.
Your Honor, this is not offered for the truth of the matter that they, whoever they may be, told Mr. Ray to make Nathan understand. It simply points to the defendant's then existing mental state.
But let me make sure I understand the position. The testimony was that Mr. Ray had told the detective that they had said something. Why is Mr. Ray's statement not hearsay to prove the fact that they told him because Mr. Ray said they told him?
Well, we understand from the direct that Officer Booth, or I'm sorry, I keep doing that. I very much apologize, Detective. That Detective Booth was alone in the interrogation room with Mr. Ray at this point. And as they pointed out earlier, that no one was around, I apologize if they did not, but I thought I recalled that the direct of Detective Booth made clear that Mr. Ray was the only person around Nathan when he was murdered.
Mr. Symbol, any response?
Yes, Your Honor. The opposing counsel does not have any exception. Can you see me, Your Honor?
Yes.
Okay, I just was, I see that my internet connection seemed to be a little unstable for a moment. The opposing counsel does not have an exception to bring this hearsay in. They can't bring it in under opposing party exception, 801D2, as this is their own client. And I don't believe they've stated a reason for why this particular evidence can come in. And as long as they don't use these statements regarding the CIA and the voices he hears for the truth asserted throughout the rest of this trial, then perhaps in that case we'll concede it's not hearsay.
What I'll rule at this point is certainly we've discussed two levels of statements supposedly. One was that whoever they is, what they said as a command by fictional voices in someone's head. I'd find certainly that's not hearsay, not to prove the truth of what they said. But Mr. Ray's statements that they told him something to prove that he believes, to prove that they told him something that actually happened and he heard that. I would find that is to prove the truth of the matter asserted. It's not a party opponent, and absent a different exception, I'd sustain the objection. The jury would disregard that last comment, but I'll turn it back over to Mr. Ephraim. You may continue.
Move to strike, Your Honor.
Granted, the motion to strike is granted. The jury will disregard the last question and answer.
Thank you, Your Honor.
Detective Booth, during your interview, you called Mr. Ray a piece of shit.
I believe I did, yes.
And nothing about this interview was odd to you?
Mr. Ray mentioning the CIA did appear a bit strange, but other than that, nothing seemed very odd.
So other than that, nothing seemed odd to you?
Correct.
Do I have that right?
Yes, correct.
Your Honor, I'd like to turn back to Exhibit 1, the preliminary hearing And I'm going to read from just a couple lines down, lines 16 through 17 from the same page. Question why?
Which page is that?
29.
Thank you. Go ahead.
Question why? Answer, I can't really explain it. I could just tell. You can tell when someone is there, and you can tell when someone understands you and is part of a conversation. Nothing the defendant said was odd. It was a normal interview, and I could tell they understood what was happening and understood my questions. Did I read that correctly?
You did.
Detective Booth, you could have requested the video of the interview be preserved for evidence. Is that right?
Correct.
You decided not to preserve the video and instead chose for just a transcript?
That's correct. I did preserve the transcript, but not the video.
No further questions, Your Honor.
Thank you. Is there any redirect examination?
No, Your Honor. The witness may be excused.
All right. Detective Booth has already followed that advice. With that, then, thank you very much. We'll shift over to the state's next witness. You may call your second witness.
Yes, Your Honor, we call Dr. LaGreca to the stand.
Thank you. And we'll also there we go. We've got both counsel. Dr. LaGreca, thank you very much. You've been constructively sworn in as a witness at this point. If I could have you begin by stating and spelling your name, please.
Thank you, Your Honor. My name is Dr. Mac LaGreca, last name Lagreca.
Dr. LaGreca, thank you very much. And Ms. Jackson, when you're ready, you may inquire.
Thank you, Your Honor. Good afternoon, Dr. LaGreca. What do you do for a living?
Good afternoon. I'm a licensed forensic psychiatrist.
What is a forensic psychiatrist?
Well, generally, psychiatrists are physicians who specialize in treating mental health disorders. So a forensic psychiatrist, or as one, I specialize in not only the aspect of mental health, but how it relates to the law. So that includes things like consulting attorneys and law enforcement and being an expert witness.
And have you come here today to give your opinion regarding Timothy Ray's mental health on the day that he killed his son, Nathan Ray?
I have, yes.
Now we'll get to your opinion in a moment, but first I'd like to discuss your background. Where did you complete your education to become a forensic psychiatrist?
Sure, a long journey. I got my bachelor's degree from the University of Delaware, graduated with a chemistry degree. I went on to UPenn to get my medical degree. And afterwards, I went out to UCLA to complete my residency in psychiatry. And then I came back to UPenn to do an additional year fellowship in forensic psychiatry.
And after completing your education, what did you do for work? What did you do to practice?
Well, I practiced privately for over 2 decades. I was working with a very diverse patient population, and we'd see all sorts of mental illnesses and disorders, including schizophrenia.
Do you still treat patients today?
Yeah, today I treat patients in the capacity as a program director for the local medical school, and I see patients once a week at the hospital.
Outside of working as a program director, is there anything else that you do for work?
Just working with the medical students and in the local medical school as well.
Your Honor, we tender Dr. LaGreca as an expert of forensic psychiatry.
Is there any objection or voir dire?
No, Your Honor, no objection.
All right, he'll be so accepted. May I offer opinion testimony pursuant to Rule 702. You may proceed.
Now, Dr. LaGreca, earlier we heard that you have an opinion regarding Timothy Ray's mental health. What is that opinion?
Objection, Your Honor, lacks foundation.
Your response is to foundation.
Yes, Your Honor, we can lay foundation. We're actually getting that here. I'm going to ask Dr. LaGreca what his reasons are.
And let me go back to Mr. Allison. In what area did you believe the foundation was missing?
Your Honor, there's been no foundation laid as to any documents or interviews that Dr. LaGreca has reviewed at this point. So it's unclear as to how he is making an opinion on this case without any of that information.
And I probably jumped the gun going to Ms. Jackson before clarifying the foundation. Any responses to that particular issue?
No, Your Honor, I can lay foundation regarding Dr. LaGreca's opinion by asking him how he elicited his opinion for Mr. Timothy Ray's mental health.
What I'll do is I'll find under Rule 705 that an expert can testify to the opinion before giving the reasons for it and give the reasons for it without testifying to the underlying facts or data. However, I'll let you lay that foundation. I'm going to overrule the objection, but I'll let you go ahead and move on to lay that foundation in any event.
Thank you, Your Honor. Dr. LaGreca, how did you come to your opinion today?
Well, just from my experience dealing with patients with mental health disorders and by reviewing all the materials given to me.
Thank you. Now I'd like to go back to the reasons that why you've created your opinion regarding Mr. Timothy Ray's mental health. Can you tell us what those reasons are?
Certainly. My reasons for why I believe Mr. Ray was not suffering from schizophrenia are: one, his previous diagnoses and evaluations show that he never suffered from schizophrenia. My second reason is that Mr. Ray showed signs consistent with malingering after the criminal act. And then lastly is the manner in which he actually killed Nathan Ray. It showed to me that he wasn't suffering from schizophrenia.
Your Honor, may we have permission to publish a demonstrative to lay the foundation for Dr. LaGreca's opinion today?
And would this be shown to the jury or just to the court and counsel and the witness?
It's a court and counsel outside of the presence of the jury.
You may go ahead and do so.
Thank you. Dr. LaGreca, I'd like to talk about your first main opinion regarding Mr. Timothy Ray's health. How did the defendant's diagnoses and evaluations that you reviewed play into the opinion today?
Yeah, well, back in 2010, according to the review records, Dr. Riley performed a full psych eval on Mr. Ray, diagnosing him with general anxiety disorder. And he was—
Objection, Your Honor. Hearsay and lack of foundation.
Ms. Jackson, your response to hearsay and foundation.
Yes, Your Honor, I can lay foundation by asking the defendant, by asking Dr. LaGreca. Dr. LaGreca.
And then as to hearsay, what's the response as to hearsay?
Yes, this isn't hearsay, Your Honor. In fact, this statement that Dr. LaGreca is providing survives the 703 reverse 403 analysis. The statement given by and materials reviewed by Dr. LaGreca were used as the basis for his opinion. Therefore, it does not substantially outweigh the probative value. And furthermore, Dr. LaGreca's statement today should be reviewed by the jury so that the jury can consider it in determining whether or not Dr. LaGreca's statements today are sufficient to his opinion.
Right. Mr. Allison, presumably that Ms. Jackson lays the foundation, what was your responses to the hearsay issue?
Your Honor, I would still contend that she has not laid the foundation because she hasn't referenced any specific documents, just that he reviewed the case document, which is a broad document that contains lots of exhibits that he could be referring to, but it's unclear what exactly he is referring to. And as far as hearsay, it seems like there may be a misstatement of the rule. It has to be that the probative value substantially outweighs the prejudicial effect. And if I was hearing opposing counsel correctly, it appears that she may have conflated those two.
And let me make sure I understand, as to your position as to why it was hearsay, what was the position in terms of that?
Oh, Your Honor, this is hearsay. While a foundation hasn't been set as to what Dr. LaGreca is referencing, I do believe that he is referencing a report that Dr. Riley conducted, which is an out-of-court statement asserting, at least in Dr. Riley's words, that Mr. Ray did have schizophrenia.
what I'll find at this point is Ms. Jackson's indicated she plans to lay additional foundation. I'll let her do that first. Mr. Allison, if you believe she does not complete that, I'll let you come back and reassert the objection at that time. But since the prosecution, I believe, is not trying to introduce Dr. Riley's statement as proof that Dr. Riley's opinions are correct, since they contest those and find it was non-hearsay, so it overrules the hearsay, but I'd let Ms. Jackson go ahead and proceed in terms of laying the additional foundation, and we'll go from there. So one objection is sustained, one is overruled.
Your Honor, may I present one more point here?
You may.
Thank you. The report that Dr. LaGreca is relying upon is the same report that the defense's expert, Dr. Riley, is relying upon as well. Dr. LaGreca is not presenting any additional information outside of what the defense relied on in creating their opinion either.
At this point, since the witness has not testified to that, I would accept that potentially for the offer of proof regarding the hearsay issue, but for the foundation, I think the witness should establish what he's relying on in that regard. So I'll let you go ahead and lay that foundation to the witness, and you may proceed.
Thank you. Dr. LaGreca, what documents or evaluations did you use in formulating your opinion regarding Mr. Ray's mental health?
Well, as a forensic psychiatrist, I also refer to what we call the DSM-5. It's a manual all forensic psychiatrists use. It's within my purview of clinical training. In addition to all the other things I mentioned earlier.
And outside of the DSM-5, did you rely on Dr. Riley's psychiatric evaluation?
Your Honor, leading.
I'll overrule at this point. It was a foundational question. It's a yes or no question, but I'll let the witness establish whether or not that was something he relied upon. In discretion under Rule 611, objections overruled. You may continue.
Dr. LaGreca, you may answer the question. Did you rely on Dr. Riley's report in consideration of your opinion?
Yes, I did.
Now you mentioned the DSM-5. What is the DSM-5?
The DSM-5, it's short for Diagnostic and Statistical Manual for Mental Disorders. It's, like I said before, it's a list of a variety of mental health disorders that all physicians and forensic psychiatrists use in diagnosing symptoms and criteria for things like schizophrenia or anything else.
Referring court and counsel to what has been pre-marked as Exhibit 17A, Your Honor, may we publish Exhibit 17A to lay the proper foundation for the DSM-5?
Again, under the prior agreements that this is being shown not to the jury, but to the court, you may go ahead and show that.
Thank you. Dr. LaGreca, do you recognize what's on your screen?
Yes, I do.
What is that?
It's just an excerpt from the DSM-5 describing what schizophrenia is.
And how do you recognize the DSM-5?
Just from my training and reviewing the records for the case.
Is this an accurate depiction of what you used to review the records today in Mr. Timothy Ray's mental state?
Yes, it is.
Your Honor, the people move Exhibit 17A for identification into evidence.
Any objection to the admission of 17A?
No, Your Honor.
Exhibit 17A is admitted, and you may show that to the jury.
Thank you, Your Honor. Now, Dr. LaGreca.
Go ahead.
Thank you. Now, Dr. LaGreca, what were some of the malingering symptoms that you observed in your report?
Well, Mr. Ray, looking at the report, Mr. Ray showed 3 of the 4 symptoms. One of them was being sort of the, how to describe this, the context of this whole evaluation.
And is it your expert opinion that the defendant faked symptoms?
Yes, it is. He did several times, to be honest.
How so?
Well, when he was, every time he had these symptoms that we would list as abnormal, it was within the contents of a criminal evaluation. Like when Dr. Riley was interviewing him, he started talking about things about auditory hallucinations from a young age and things like that.
Objection, Your Honor. This is a mischaracterization of the evidence.
Tell me more what you mean by that. What prior evidence does it mischaracterize?
Your Honor, the witness stated that every time that these auditory hallucinations, as he put it, were referenced, it was because he was being examined for criminal proceeding, and that is not accurate with how the facts are portrayed. He just referenced hearing voices when he was 10 years old, and he was not under criminal prosecution or threat of criminal sanction when he was 10. The defendant, that is.
I'm going to overrule that as the objection to the admissibility of the statement itself. If you disagree with the position of the witness, I'll let you cross-examine him on that issue, but I'll overrule as to mischaracterizing the evidence. And with that, Ms. Jackson, you may continue.
Thank you, Your Honor. Dr. LaGreca, were there any discrepancies within the reports that you reviewed?
Yes, there were.
What were they?
Well, first was when Mr. Ray had mentioned having suicidal thoughts. Then during the interview, while he's under the face of these charges, he then expresses having suicidal thoughts when he had previously never mentioned it before.
Is there anything else?
Yeah, he also mentioned seeing triangles changing shapes and colors. Again, things that were not in the documents from his prior evaluation.
What about his behavior with others?
His interaction with law enforcement also favored malingering, in my opinion.
How so?
Well, he starts by lying to law enforcement about his ID, and once they find his ID and they're about to figure out who he is, he starts having his most exaggerated symptoms.
What do you mean by exaggerated?
Well, he's according to the record, he starts rambling to himself, doing jumping jacks in the streets, yelling from the car, just abnormal behavior, and just from doing this for a long time, it's clear within that scenario, it seemed as if he was faking it.
What else was worth mentioning?
Well, all in schizophrenia, in true schizophrenia, a patient would actually experience two or more of the symptoms of schizophrenia at the same time instead of in certain instances. Instead, we have a textbook definition of malingering: grossly exaggerated physical or psychological symptoms motivated by external incentives.
Incentives like what?
Well, like evading a criminal prosecution.
Now, let's go to your third main opinion. Can you tell us how that led to your overall opinion in this case?
Yeah, so the conscious choice Mr. Ray took to kill Nathan was my last concluding reason. The way he killed him, basically. First, Mr. Ray makes a conscious decision to punish Nathan for what he did, and then he goes to his bedroom to calm down, and then he grabs his belt to strangle his son with.
And why is this important to your opinion?
Well, it's important because it's not as if it was a split-second decision or a crime of passion or anything like that. He calmed down, and then he decided to grab a belt and punish Nathan by hitting him with it. Then he tries to get away with it, and he hid the evidence.
Now, you keep mentioning the term punish. Hypothetically speaking, how does that term factor into your opinion? And why is that important?
Right. Well, when someone punishes another person, that's because that person thinks the other person did a wrong. If that's the case, that means they know what's right and what's wrong. So,
Objection, Your Honor. This answer is outside the scope of his expertise. determining what punishment is in any context isn't a matter for a forensic psychologist, maybe a behavioral scientist, but not for his expertise.
And Ms. Jackson, your response.
Yes, Your Honor. Dr. LaGreca is not providing anything outside of the scope. However, he is permitted as an expert here to provide a hypothetical or generic response as it relates to the facts of this case. And as we all hear, this is exactly what Dr. LaGreca is doing today.
And as an offer of proof, since we're outside the hearing of the jury, what is it that you believe that answer would be in terms of the punishment? What is it you're expecting that the witness will say?
I would like to hear whether or not the theory that Dr. LaGreca is stating regarding punishment is in line with what someone who has schizophrenia would do.
All right. Ms. Johnson, in light of that offer, any response?
Your Honor, I still think it's outside the scope for him to determine what punishment is in any given context. That seems extremely vague. We're also starting to touch on the ultimate issue here, because whether or not Mr. Ray had the intention of punishing and knew what he was doing, the ultimate issue here is whether or not he knew right from wrong. And by offering testimony that he would have known what he was doing, we're touching on the ultimate issue.
And very quickly, ultimate issue is a different issue. Ms. Jackson, any response?
Yes, Your Honor. As we know in Pasquarello, the expert is allowed to embrace the ultimate issue, and in line with 704A, just because an expert tracks the line of an expert of the ultimate issue, it does not make it automatically objectionable. And furthermore, Dr. LaGreca is just speaking in terms of a hypothetical.
At this point, I would agree we could go too far with an expert testifying about what punishment is as a psychiatrist. However, testimony is going to how he applied that punishment to his decision on the mental state and schizophrenia. So I'd overrule on that basis unless it goes any further. And it's the ultimate issue, since he's not going to the required elemental mental state. I don't think it falls under the exception under Rule 704B. So I'll overrule on that basis. We're close to the line. It was a good issue, but objection's overruled. Ms. Jackson, you can continue with the examination.
Thank you, Your Honor. Dr. LaGreca, based on the facts that have been presented in the report, is there anything about the defendant's behavior that would lead you to believe that he has schizophrenia?
No, there's not. Now, whether he has is suffering from some sort of mental illness, that's something I'd have to evaluate more in person.
And no further questions, Your Honor.
In that case, is there any cross-examination?
Yes, Your Honor. May I proceed?
You may.
Dr. LaGreca, I'd like to talk to you a little bit about the psychiatric work that was done on this case. You did not conduct any interviews of anyone that actually knew Mr. Ray. Isn't that correct?
That is correct. I only reviewed not only my expertise, but the materials given to me.
So you relied on the interviews and interpretations of those interviews that Dr. Riley conducted.
And the interviews he conducted with the three other people. I wanted to interview Mr. Ray personally, again, conducting evaluation.
And knowing that Dr. Riley conducted the interviews and interpreted those interviews, you came to a different conclusion.
Correct.
And you knew that Dr. Riley interpreted those interviews to mean that Mr. Ray had schizophrenia.
Yeah, his clinical diagnosis seemed to lean that way, yes.
And although you didn't have access to Mr. Ray, you could have interviewed Mr. Ray's father.
I believe I could have.
And you also could have interviewed Mr. Ray's wife.
Yes.
And you also could have interviewed Mr. Ray's employer.
That's correct.
Instead of doing those interviews yourself, you just relied on the interviews that Major Riley did.
and my clinical assessments of those interpretations. I think all the interviews, I I would have asked the same questions Mr. Riley would have asked. I don't think it would have served a purpose to, you know, continue to re-interview these people you mentioned.
Well, let's talk a little bit about why you came to a different conclusion. You've been an expert witness before.
Yeah, 7 times.
And 6 of those 7 times has been for the prosecution.
Yeah, I believe so, yes.
And you're also being paid for your work.
I am being paid like every other psychiatrist. Yeah, we get a flat rate and an hourly rate.
$500 an hour to review materials?
That is my rate based off of, you know, just traveling and lodging and other factors.
And you've reviewed materials for 25 hours prior to trial.
That is correct.
And you're also being paid a rate to testify today.
Yes, my flat testimonial rate.
Which is $1,750.
Yes, that is correct.
And you're being paid for your opinion.
Yes.
And it's the prosecution that's paying you for your opinion today.
That is who hired me. Yes, that's yes.
Okay, I'd like to move on to some of your analysis of malingering. You have no publications in the field of forensic psychiatry.
No, I've been practicing in private practice for over 2 decades. So I have not gone over to academia until recently. I'm currently working on a paper as we speak.
So as we have established with your use of Dr. Riley's interviews, you also rely on other people's research when forming your opinions.
On other people's research, no. I use my clinical astuteness counsel.
You didn't rely on any outside research when forming your opinion on malingering?
Well, other than the DSM-5, which is something all forensic psychiatrists use in their training.
Dr. LaGreca, I would like to turn your attention to, let's see, it would be Exhibit 14, which is on, and then page, it's on page 74. Could you let me know when you get to page 74, please?
Yes.
Okay. Do you see the very bottom paragraph of page 74 underneath what's headed as section B?
Yes, I do.
I'm going to read part of that last paragraph, and I would like you to silently follow along with me. I'm going to start, I think it's the 3rd sentence that start with studies. Studies show that malingering is present in 19% of subjects who are interviewed in the context of a criminal case. Did I read that correctly?
Yes.
And you relied on these studies in order to form your opinion.
Yes.
And those studies showed that 19% of people when interviewed in a criminal context are malingering.
I believe it's sort of said what it means by that is a likelihood. So it's hard to sort of cause in a situation. It's hard to say like this is a situation and so this must be malingering.
Again, I would turn your attention back to page 74, and I'll read that sentence if you'd read it along quietly with me. Studies show that malingering is present in 19% of subjects who are interviewed in the context of a criminal case. Did I read that correctly?
Yes.
That study says that 19% of people when interviewed in a criminal context are malingering. Isn't that correct?
That is correct.
Which means that 81% of people in a criminal context would not be malingering.
Yes.
Which means that statistically, it's far more likely that a person is telling a truth about their mental condition in a criminal context.
I would say I'd have to look at it contextually, depending on the situation. But yeah, the studies do show majority of the time it may not be malingering, but in this context, I don't think that's the case.
But statistically, just applying the study that you cited and relied on to Mr. Ray, it would be statistically far more likely that Mr. Ray is telling the truth?
Well, I would say that's hard for me to say, counsel, because I have to also just bring into fact of my clinical experience and recognize the certain patterns.
While I appreciate your expertise, I'm specifically referring to this study that you cited and how that applies to Mr. Ray. So statistically, it is far more likely that Mr. Ray is telling the truth based on a study that you relied upon.
I believe this. I would say it's in a general sense, yes, but it'd be hard for me to say for this specific case.
But generally, it's statistically more likely that Mr. Ray is telling the truth. That's what you said?
I would say generally within all cases of criminal investigation, not necessarily this particular case.
Well, Mr. Ray's case is in that general all category of all criminal cases, isn't it?
Yes, that's correct.
Okay. I'd like to just talk to you about one more thing. You said that on direct that Mr. Ray was not exhibiting two symptoms at the same time, correct?
Correct.
You would agree with me that Mr. Ray was hearing voices based on the materials you observed, that the voices were telling him his wife was having an affair.
Well, those voices, according to the materials we reviewed, he was eliciting that in the context of a criminal investigation.
My question's a little bit more narrow than that.
Mm-hmm.
He did tell Dr. Riley that he was hearing voices that his wife was cheating on him, correct?
Oh, that's correct.
And those voices were telling him that 2 years before Mrs. Ray was cheating on Mr. Ray, isn't that correct?
During that criminal investigation, during that interview, rather, within the criminal investigation, yes, that was said.
And delusions essentially are believing something that's not actually true.
Correct.
And Mrs. Ray wasn't cheating on her husband when he was hearing those voices.
I'm not sure. I'm not too sure about that.
Okay. No worries about that. Your Honor, no further questions at this time.
Ms. Jackson, is there any redirect examination?
Yes. Dr. LaGreca, can you tell the jury why you were not able to interview the defendant in this case?
Well, I asked Mr. Ray's attorneys to conduct an in-person interview, but they didn't produce the client for evaluation.
And my last question, did Timothy Ray fall within that 19% of people who are believed to malinger?
I believe so, yes.
No further questions, Your Honor.
Thank you. At that point then, Dr. LaGreca, you're free to step down. We appreciate you being present. Does the state have any additional witnesses?
No, Your Honor, but at this time, the people would like to read in stipulation for the record.
You may.
People move to admit autopsy report Exhibit 6, missing person report Exhibit 7, and prison medical records Exhibit 8 as admissible per stipulation 4.
Any objection to the admission of 6, 7, 8 or disagreement with the stipulation by the defense?
Your Honor, we agree that the stipulations are in the rules.
In that case, Exhibits 6, 7, 8, 6, 7, and 8 are admitted.
Thank you, Your Honor. Before we proceed, if we could also get a time check.
Actually, I wanted to get to that for certain, but since the next section is untimed, since it's motions, it's not participation, I just want to verify, did the people have any additional evidence?
No, Your Honor, the prosecution rests.
All right. Were there any motions by the defense at this time?
Yes, Your Honor, at this time, pursuant to Rule 29 of the Federal Rules of Criminal Procedure, we move for a acquittal as a motion of, or as a matter of law, because the state has not met their burden of proof of beyond a reasonable doubt at this time.
Are there any specific elements that you think have not been met, or it's just a general objection?
It's a general objection at this time, Your Honor.
Mr. Symbol, any response?
Yes, Your Honor. Federal Rule of Evidence 29 states that the prosecution must present enough evidence for a reasonable juror to believe that the defendant committed the crime. We've presented more than enough evidence here to account for the fact that the defendant did indeed commit the murder of his son, that he did kill Nathan, and that he acted with malice aforethought in doing so. We've presented enough evidence to show that he had the necessary intent, and furthermore, to contravene the claim he's making as to schizophrenia to invalidate his intent. That being said, with all the evidence that's been presented, we've met this low standard to overcome the motion.
Mr. Ellison, any reply?
Your Honor, we just would continue to assert that we're moving for acquittal as a matter of law at this point.
That's completely acceptable under the circumstances. I'll find that looking at the evidence in the light most favorable to the non-moving party, the prosecution, there is sufficient evidence upon which a jury could find, depending on how they interpret that evidence, that each of the elements could be proven beyond a reasonable doubt. Therefore, I'll deny at this time the motion for a judgment of acquittal or directed verdict, and we'll go ahead and proceed to the second half of the case in a moment. What I'd like to do is two things. The second is going to be we'll take a short recess. But the first, though, Mr. Symbol, I agree with you. Let me do a time check with both of our timekeepers. How much time is remaining? Do you show remaining for the prosecution?
Your Honor, for the prosecution, we have 26 minutes and 8 seconds remaining. And for the defense, 32 minutes and 24 seconds. I've been conferring with the opposing timekeeper, and that's what we have so far.
And for our defense timekeeper, I think I saw you nodding, but do you agree that that's the amount of time left?
Yes, Judge, we're in agreement.
All right. Why don't we go ahead and take about a 5-minute recess so anyone can use the restroom. I show that it's now 3:15. Oh, sorry, it's almost exactly 4 o'clock. So if we can be ready to resume at 4:05, we'll resume with the defense case in chief at that time. We'll take 5 minutes. And if you're back and ready, I'll let council reactivate their cameras. All right. Looks like all council are present. Let me check in with our jurors as well. Do we have all three jurors? And I'll let you identify yourself one at a time.
Yes, Andrew Hillier's back.
Mr. Hillier, thank you very much. Either Mr. Anderson or Ms. Falkenstein, are you back?
Yes, Your Honor, I'm back.
Thank you. We're getting close. And Mr. Anderson, when you're there, let me know. And you may have been muted if you were answering. It looked like it muted and unmuted, but all right. And do we have, Mr. Anderson, do we have our third juror back?
I'm here, Your Honor.
Thank you very much. I appreciate that. In that case, we'll go ahead and we'll resume with the second half of the trial, beginning with the defense case in chief at this point. First, are the people ready to, sorry, is the state ready to resume?
Yes, Your Honor, we are.
All right. In that case, we'll turn over to the defense. Mr. Allison, are you ready to call your first witness?
Yes, we are. At this time, the defense would like to call Officer Peyton Wentz to the stand.
All right. Officer Wentz, we'll presume that you've been constructively sworn at this time, so I'll have you begin by please stating your name.
Yes, my name is Officer Peyton Wentz.
All right. With that then, Mr. Allison, when you're ready, you may inquire.
Officer Wentz, could you please tell the jury what your occupation is?
Of course, I'm a police officer with the Skelton PD.
And what is your relationship to Mr. Ray's case?
Well, I was actually the first officer to make contact with Mr. Ray after he murdered his son. I'm the officer that originally detained him.
Officer Wentz, I'd like to talk about your initial interactions with Mr. Ray. What were you doing when you first contacted Mr. Ray?
I was working that evening at a sobriety checkpoint.
And when Mr. Ray approached your checkpoint, what did you do?
I asked him to roll down his window so that I could speak with him.
Did you make any initial observations about Mr. Ray?
Yes, there was odor emanating from his car. He looked very disheveled and his clothes were stained. To me, it looked like he'd been living in his car for a couple of days.
Could you just briefly describe what that odor was?
It was body odor, like he hadn't showered.
And after you made these observations, Officer Wentz, what did you do?
Well, I asked him for his license and registration, standard protocol.
Officer Wentz, did you comply with your order?
No, not at first. He actually told me that he forgot his wallet at home. I thought that was strange because I could see his wallet laying in the front seat.
Officer Wentz, did he eventually comply with your order to hand over his license and registration?
Yes, after I repeatedly insisted, he eventually reluctantly handed over his license, followed by his registration shortly after.
After obtaining his license and registrations, what did you do next?
Well, I went to take that information back to my partner at the cruiser so he could run the information through the system.
Did you make any observations on your way back to the cruiser?
Yes, as I was walking back to the cruiser, I stopped at the defendant's rear window and I shined my flashlight through the window and I saw some very suspicious items.
Could you tell us a little bit about those suspicious items?
Yeah, I saw 2 big bottles of bleach, trash bags, and what looked like a bloody shovel.
After you had given your partner, Mr. Ray's information, and after you gave him the information, what did you do next?
I walked over to Timothy's vehicle where he had remained seated.
And what observations did you make once you got back to Mr. Ray's vehicle?
He started acting totally crazy. He was frantically saying that he could hear the sirens of the CIA, and he was asking me if I was CIA, even though I had just explained to him this was a routine traffic stop.
Officer Wentz, were there any sirens going on at that time?
No, our sirens weren't even on, let alone CIA sirens.
Officer Wentz, how would you describe Mr. Ray's demeanor at this time?
Frantic, nervous. I was trying to talk to him, but it seemed like he couldn't hear me.
And Officer Wentz, what did you do in the face of such crazy behavior as you described it?
I tried to calm him down once again and tell him that I work for the Skelton PD. I even pointed to my badge to show him. And at that point, I felt it was best to ask him to step out of the vehicle.
Officer Wentz, I'd like to take a moment and discuss with you a little bit about your education and training. How long have you been a police officer, Officer Wentz?
I've been with the Skelton Police Department for about 2 years now.
Officer Wentz, what is the highest level of education that you've completed?
I have a bachelor's degree in criminology.
Officer Wentz, did you complete any training specific to being a police officer?
Well, I passed the police academy, obviously.
And during your time in the police academy, did you complete any training specific to mental health and how you may interact with that in the public?
Yes, actually, I completed a 40-hour course that we refer to as Crisis Intervention Training, or CIT.
And Officer Wentz, what type of things did you learn in crisis intervention training?
I was basically taught to recognize and react to people that were struggling with mental issues.
Did you utilize your crisis intervention training at all when interacting with Mr. Ray?
Oh, yeah, to me, I definitely recognized some symptoms. To me, it seemed like he was crazy. The guy didn't seem right in the head from start to finish. In our entire interaction, I really thought that he needed medical help.
Objection, Your Honor.
Please go ahead. Yes.
Improper layperson.
All right. Mr. Allison, your response is it's an improper lay opinion.
Your Honor, the witness is simply stating what he believed about the defendant after his observations. He's not using any clinical or medical training or diagnosis to inform his decision, merely stating what he believed he was witnessing through his own firsthand observations.
Well, since he's reaching a conclusion as to a mental state, how is he qualified to make that observation? It's not based on rationally based perception, such as somebody was going fast or is tall. How is this not an expert opinion?
Your Honor, I would argue that he's not giving a conclusion as to a mental state. He's simply characterizing the behavior that he witnessed.
Ms. Jackson, any response?
Yes, Your Honor. The issue, the ultimate issue, the mental health of Timothy Ray is for the trier of fact, as you previously stated, but we want to be sure that the jury is not confused in any way as to Mr. Wentz's ultimate conclusions of Mr. Timothy Ray's mental health. He should solely be discussing the actions and behaviors that Mr. Ray exhibited during the stop.
Your Honor, may be heard on those grounds.
You may, absolutely.
Your Honor, I would be completely willing to ask a follow-up question that he's not making any of these bases based on a medical opinion or diagnosis, that he's simply characterizing using common parlance what he's observing.
I find at this point, especially in light of the fact that you laid foundation about certain training regarding dealing with individuals, it suggests to the jury that this is in fact a qualified opinion based on specialized training or experience. But more importantly, it's not a standard lay opinion under Rule 701. The officer can testify about what he saw, what he observed, what the behaviors were. The jury can decide whether or not that's an indication of that someone may have schizophrenia based on the other testimony. But I'll sustain the objection as to reaching a conclusion about that he was crazy or acting crazy. And with that, I'll partially sustain the objection and let you focus instead on the observations as opposed to the conclusions.
May I proceed?
You may proceed. And we've lost our other eight. Go ahead.
Officer Wentz, could you please describe the type of people that you typically interact with?
Yeah, most people are compliant at these DUI checkpoints. It's sort of a perfunctory interaction for the most part. So most people comply with the instructions, and they're at least in tune enough with reality to respond in an effective manner.
Officer Wentz, were your observations and interactions with Mr. Ray at all typical with your normal course of business as a police officer?
No, absolutely not. He went from crying to being in a zombie-like trance. He seemed like he was hearing things and talking to himself. He acted like I wasn't even there, as if he was having delusions.
Thank you. Officer Wentz, I'd like to move back to your interactions with Mr. Ray after you asked him to get out of the vehicle. When you asked Mr. Ray to get out of the vehicle, did you comply with your order?
No, not at first. He kept asking for my CIA credentials, as if I didn't just explain to him that I don't work for the CIA. I had to explain who I was again, and he finally got out of the car.
And when he got out of the vehicle, what observations did you make?
Oh, it was like he completely changed. He was paranoid and antsy earlier, but when he got out of the car, he had a completely blank stare on his face, like zombie-like.
Objection, Your Honor. Improper lay opinion once again.
Any response?
Your Honor, he simply stated that he was in a zombie-like trance. He's just trying to use his own language in order to describe his observations. He's not making a statement as to the defendant's mental health.
Ms. Jackson, any reply?
Yes, Your Honor. In his response, he also mentioned that the defendant was paranoid, which is a direct symptom stated within the DSM-5. And as we know, Officer Wentz is not an expert witness here. He has not been tendered, and he does not have qualified experience enough to appreciate this type of mental illness.
I think it's a proper objection given the language, although paranoid is somewhat different in my mind. It wasn't seem to be offered as a description of a DSM-5 category or mental state, but more of its common parlance. I think there's less risk of confusion as with the term crazy. And so I'd let you follow up on cross-examination to establish to the jury that that was just simply a common description. It wasn't a medical finding, but I'll overrule, let the jury consider that and weigh it. Objections overruled. You may ask the next question. The answer stands.
Officer Wentz, was Mr. Ray making any statements during this time?
Yeah. He was saying that he was a good father and that he didn't mean it like 3 times. But it was weird because once again, he wasn't talking to me. It was like he was talking to someone that wasn't there or no one at all.
Officer Wentz, did Mr. Ray ever leave this zombie-like trance?
Yeah, he like snapped back to reality. He told me that he was just trying to get his son in shape and make him admit what he broke, and that he wanted his son to do jumping jacks.
Officer Wentz, after making these observations, what happened next?
Mr. Ray himself started doing jumping jacks. I ordered him to stop, and once again, he refused to comply, so I drew my weapon on him.
And what did Mr. Ray do in response to you drawing your weapon?
Well, he put his hands over his head like a little kid that was trying not to hear something. Eventually, I was able to get his hands down and get him properly cuffed.
And after you got him handcuffed and detained, what happened?
He started rambling on about his son.
And after observing these ramblings about his son and having him handcuffed, what did you do?
That's when I radioed this into the station. My partner called me back over to the cruiser and told me that the plates were flagged in a missing persons report involving a little boy.
And you mentioned CIT training earlier. Did that factor at all when you were making your call over the radio?
Yes, of course. I try to be cognizant of all my training.
And did you specifically request an EMT?
No, not explicitly.
What specifically did you radio?
I reported that he seemed to me to be crazy and totally off his rocker.
And why didn't you specifically request an EMT?
I figured based on my description that they would send one. I was somewhat surprised when they didn't. The guy really seemed like he was having delusions our entire interaction.
Objection, Your Honor. Improper lay opinion.
Your response.
Your Honor, I'm willing to withdraw that question. I have no further questions at this time.
All right, questions withdrawn. The jury is instructed to disregard the last answer. And with that, we can go ahead and turn that over to cross-examination.
Your Honor, before we move to cross-examination, can we move to strike that statement from the record?
So that was the intent of instructing the jury to disregard, so I grant the motion to strike.
Thank you.
Thank you.
Now, Officer Wentz, I'd like to talk to you about your interaction with the defendant on October 19th. You were the first person to come into contact with the defendant after he killed his son, weren't you?
Yes, I believe that's correct.
He was stopped at a DUI checkpoint.
Yes, I've been working on a DUI checkpoint that evening.
And you noticed some suspicious items in his backseat, didn't you?
I did. When I shined my flashlight back there, I noticed the items that I described on direct.
There was a shovel.
Yeah, a shovel, 2 bottles of bleach, and some trash bags.
And the shovel looked like it might have had blood on it.
Yes, as I testified on direct, the shovel looked like it might have had some blood on it.
And this raised a red flag for you, correct?
Oh, yeah. I thought that these items were a little bit suspicious.
Which is why you asked the defendant for his driver's license?
Well, not necessarily. I asked him for his license and registration prior to seeing those items.
Yeah, well, it's routine that you would ask for a driver's license or car registration, but it didn't seem routine to the defendant, did it?
I cannot really testify about what the defendant thought or saw. I do think that it's pretty standard protocol to ask for license and registration for the vehicle.
Well, you mentioned the defendant's behavior as strange, correct?
Oh, yeah, this guy was off his rocker. He was crazy.
And after you asked for his ID, he lied to you, didn't he?
Yeah, he tried telling me that he left his wallet at home, but I saw the wallet in the front seat.
And you saw the wallet in the front seat, and he lied about the registration as well. Isn't that right?
Yeah, he was very reluctant to hand over that information, for sure.
And you knew it was a lie because you found the car registration in the glove compartment of the car, correct?
Well, he eventually handed it to us. I didn't go rummaging through the glove compartment.
Yeah, so after he lied about the driver's license and the registration, you took his identification to your partner, correct?
That's correct.
And while your partner ran the defendant's information, you returned back to the defendant's vehicle.
Yes.
And you noticed something had changed when you returned.
I don't know if anything had changed. He started saying some very strange things, but he was pretty strange from the get-go.
Well, Officer Wentz, you knew that the defendant's demeanor changed when you returned.
I think his demeanor changed most significantly when he first stepped out of the vehicle, which was a little bit later than the interaction you were describing.
Well, when you returned to the vehicle, the defendant noticeably changed, didn't he?
Yeah, he started asking if I could hear CIA sirens.
He also yelled at you from the car, didn't he?
I believe that he raised his voice, yes.
And I want to be clear, he also did full-on jumping jacks in the middle of the road.
After I'd taken him out of the vehicle, yes.
And all of that behavior was very strange.
Oh, all of his behavior from the very first moment of our interaction was very strange, of course.
It was unbelievable that he was doing so many different behaviors within a short period of time, right?
I don't know if it's unbelievable. You see a lot while you were a cop, but this guy, yeah, was definitely acting in a particularly crazy manner.
Yeah, it was unlikely that someone at a normal checkpoint would do some type of motions as the defendant exhibited today, correct?
Yeah, I don't think that like a normal person would have done that. I think he was doing this because he was off his rocker.
Now, I want to get this straight. It wasn't until you returned back to the car that the defendant started asking you crazy questions?
Yes.
And he didn't say anything about the CIA until you returned, right?
No, but he had been lying about his license and he was still disheveled and acting in a very strange way.
Yeah, he was disheveled, but he hadn't said anything about the CIA, right?
Not at that point. I don't believe so.
And he definitely wasn't doing jumping jacks until he exited the vehicle, correct?
Well, it would be very difficult to do jumping jacks within the vehicle.
I agree, but it wasn't until he exited the vehicle that he began doing jumping jacks.
That is correct.
And it wasn't until you took his identification and were close to figuring out who he was that he started exhibiting all of these different behaviors.
Oh, I don't think so. I think he was dishonest with us and finicky from the very jump before I ever walked the information back to my partner.
But the questions didn't happen until you were in the process of identifying him, correct?
That's correct. That's correct.
And it wasn't until you were in the process of identifying him that he began doing jumping jacks.
Well, it was after he said that his son needed to do jumping jacks. That was just after I took him out of the police.
Yes, after you obtained his identification.
Yes, yes, ma'am.
Prior to your partner identifying him.
Yes.
No further questions, Your Honor.
Thank you. Mr. Allison, is there any redirect examination?
No, Your Honor.
All right, Officer Wentz, thank you very much. You're free to step down.
Thank you, Your Honor.
The defense is ready. You may call your next witness.
The defense calls Dr. Major Riley.
Good evening.
Good evening, Dr. Riley. Thank you very much. At this point, you're constructively sworn in. So if I could have you begin by stating and spelling your name, please.
Shane J. Riley, SHAYNEJREILLY.
Dr. Riley, thank you very much. And Mr. Ephraim, when you're ready, you may inquire.
Dr. Riley, thank you for being here. Do you prefer Dr. Riley, Major Riley, or Dr. Major Riley?
Dr. Riley's fine with me.
And what is your relationship to this case?
I am the forensic psychiatrist brought in to evaluate Mr. Timothy Ray.
What does a forensic psychiatrist do?
As a forensic psychiatrist, we focus on the relationship between psychiatry and the legal system.
Do you have a medical education?
Yes, I have a medical degree.
Could you tell us about your education, Dr. Riley?
I received my medical degree from the Edward Herbert School of Medicine at the Uniformed Services University in Bethesda. I then stayed in Bethesda for my residency and fellowship in forensic psychiatry at the Walter Reed National Military Medical Hospital.
How long did you work in the hospitals?
For 10 years.
Could you tell us about your work then?
2006, I became the managing clinical psychiatrist at the psychiatric inpatient unit at the Walter Reed Hospital. Then in 2011, I became the deputy director of the behavioral health department.
So how long have you worked in the field of psychiatry now?
For 2 decades.
Have you ever taught within the field?
Yes, I was an associate professor from 1998 to 2001 and did it again from 2007 to 2010. Have
you ever written any professional articles in the field of psychiatry?
I've written 15 peer-reviewed articles in the field of forensic psychiatry.
Have you ever written about or studied schizophrenia specifically?
Yes, I have. I have written 2 different peer-reviewed articles about schizophrenia.
Are you on any medical boards, Dr. Riley?
Yes, I have been on the American Board of Psychiatry and Neurology for the last 19 years.
You still work in the hospital now, or are you teaching?
No, I've shifted over to private practice for the last 5 years.
Dr. Riley, in forming your opinion, did you reliably apply principles and practices commonly used in your particular field?
Of course, my opinions in this report are made with a reasonable degree of medical certainty, in part based on the information and knowledge I have attained through my research and review of medical literature, my own personal experience in private practice, my education, my training, teaching others, and interaction with other psychiatrists.
Could you tell us about your experience as an expert witness in forensic psychiatry?
I have served as an expert witness in 25 previous cases. Some are court-martial proceedings, but the majority have been in criminal cases.
Your Honor, for the federal rules of evidence and the court rules that you discussed earlier, at this time, I'd like to offer Dr. Riley as an expert witness in forensic psychiatry.
Is there any objection or voir dire?
No objection, Your Honor.
All right, he'll be so accepted and may offer opinion testimony pursuant to Rule 702. You may continue.
Dr. Riley, have you formed an opinion in this case regarding Mr. Ray's mental health?
Yes, I have.
What is your opinion?
That Mr. Ray suffers from severe schizophrenia.
And how confident are you in this opinion?
With medical certainty, Mr. Ray suffers from schizophrenia.
Why is Mr. Ray's diagnosis of schizophrenia relevant to this case?
Mr. Ray's symptoms described in the materials I reviewed go back years before the need for any legal defense. They were consistent with the symptoms manifested in the months leading up to October 17, 2018, through to my clinical interview.
Dr. Riley, I'd like to start with your own interactions with the defendant. When did you first meet Timothy Ray?
My first meeting with Mr. Ray was in 2010.
And what were you doing in 2010?
I was part of a small team overseeing 20,000 troops.
Would you please tell us about this first interaction?
Mr. Ray's commanding officer, who I had served with, had him committed for a psychiatric evaluation because he had caught him hallucinating, seeing things that were not there. Mr. Ray denied the hallucinations as well as suicidal ideations at that time.
How long did you have him under your care?
Only for 3 days.
What did you diagnose him with then?
General anxiety disorder.
Why did you not diagnose him with schizophrenia then?
The Diagnostic and Statistical Manual of Mental Disorders, 5th edition, commonly known as the DSM-5, outlines the process to make a diagnosis for schizophrenia.
Dr. Riley, since your first meeting, have you had the opportunity to fully evaluate Mr. Ray?
Yes, I've conducted a full evaluation in this case. I reviewed Mr. Ray's medical history, the arrest records, police reports, depositions, transcript of preliminary hearing, and his primary care doctor's reports, as well as interviewing those who knew Mr. Ray.
Well, before we get into all that, Dr. Riley, I would like you to talk about malingering. Would you tell the court what malingering is?
Yes, it's essentially the medical term for faking it so you don't have to go to jail. This is usually characterized by production of false or exaggerated physical or logical symptoms.
And what does medical certainty mean?
Medical certainty means I have the most confidence I can, in my opinion.
Dr. Riley, are all schizophrenics violent?
No, they are not.
The ones that are violent, how can it manifest?
It will manifest through a display of violent tendencies, such as angry outbursts or aggressive behavior.
Do all schizophrenics experience symptoms so severe that they impair their ability to understand the nature of their actions?
No, some do experience this, but not all.
Is it medically certain some schizophrenics lose this ability to distinguish right and wrong?
Yes, that is true.
Have you discussed the morning of October 17th with Mr. Ray?
Yes, I have.
In your opinion, was Mr. Ray suffering from symptoms consistent with severe schizophrenia the morning of October 17th?
Yes, he was.
What led to this conclusion?
When we spoke about that morning, Mr. Ray stated he would do the same thing in front of an officer. He told me that Nathan had to be punished. He's in a better place now. No more pain, no more suffering.
Dr. Riley, earlier you mentioned the DSM-5, the Diagnostic and Statistical Manual of Mental Disorders, 5th edition. Feel free to refer to it as the DSM-5 from here on out. And I'd like to discuss that more. Do you and prosecution's expert, Dr. LaGreca, agree that the DSM-5 is a reliable authority on schizophrenia?
Yes, this is the most reliable source.
What criteria from the DSM-5 were relevant to your diagnosis?
3 symptoms: his hallucinations, his delusions, and his negative symptoms, as well as what we term disturbances: Mr. Ray's medical history, drug history, and genetics.
Did you find evidence of these criteria while evaluating Mr. Ray's case?
Yes, there was evidence for all of what I just mentioned.
How does Mr. Ray meet the hallucinations criteria?
He was having visual, but mainly auditory hallucinations.
How does Mr. Ray satisfy the delusions criteria?
Mr. Ray's paranoia regarding his wife's infidelity for the at least 2 years before the affair. The voices were pushing this idea when they really weren't there, as a delusion.
Objection. Your Honor, I have 2 objections. For one, if I could ask opposing counsel to direct their witness to read a little bit slower so I could make out exactly what they're saying. And secondly, I have an objection as to foundation for the statement just provided.
All right. Let me start with the objections, your response.
For lack of foundation, sir, or for going slower?
I would let you take them in either order.
We can certainly slow down. I have no issue with that. I'm sure it would help the trier of fact. And as for the foundation question, which question was opposing counsel referring to? How does Mr. Ray meet the hallucinations criteria? Or the question that was after that, how does Mr. Ray satisfy the delusions criteria?
I appreciate that, Mr. Simba. What is your position in terms of what is lacking in the foundation?
And that would be to the second question asked.
Go ahead.
We heard just a moment ago that 3 symptoms: hallucinations, delusions, and negative symptoms, as well as Dr. Riley continued on about disturbances, medical history, drug history, and genetics were all relevant. I then asked if there was any evidence of any of these things that Dr. Riley mentioned in his answer, to which he said, yes, there was evidence for all. At this point, I think foundation has been laid that there is enough to ask what or how Mr. Ray satisfies this delusions criteria that he's already testified Mr. Ray was experiencing.
Any reply?
Yes, Your Honor. The objection was not to the foundation regarding the initial question as to all of the evidence that the doctor relied upon, but it was more so where exactly he's getting the voices and delusions that he goes into without mentioning exactly where he obtained that information from.
Per 705, Your Honor, an expert may make an opinion as long as the information or facts relied upon are available subject to cross.
Right. I'm going to overrule that objection precisely under Rule 705. I'll allow that to be subject to inquiry on cross-examination as the rule permits. I also want to check, Dr. Riley, was there something on your screen besides just the Zoom window?
No.
All right. I just wanted to verify that. Other than that, I'll let you go ahead and resume with the testimony. Mr. Ephraim, when you're ready, you may proceed.
Dr. Riley, how does Mr. Ray satisfy the delusions criteria?
Satisfies delusion criteria from the 2 years of hearing voices before his wife even had an affair. And that it's to believe something, or it is one thing to hear something and another thing to believe it.
So it's one thing to hear something and another thing to believe it. Dr. Riley, you described auditory hallucinations as their own criteria, and I feel like you might have just conflated them. Would you please clarify that?
An auditory hallucination is hearing something that is not there, while delusion is hearing something and believing it, are two distinct different symptoms.
Dr. Riley, how do phobias, a disheveled appearance, or poor hygiene relate to your diagnosis?
These are the negative symptoms consistent with schizophrenia.
Thank you, Dr. Riley. Would you put the term disturbance into a medical context regarding the DSM-5's use of the term?
A disturbance is an event or occurrence in the schizophrenic's life that progresses their schizophrenia or triggers a psychotic episode.
Could military boot camp be a disturbance that brings on symptoms of schizophrenia?
Yes, it can.
Is it common to experience a psychotic break stemming from a disturbance during one's early 30s?
Yes, it can. It is atypical, but these common age numbers are something that being mid-20s for males and a little bit later in females is what we term common in psychiatric literature, but are not definitive cutoff ages.
Dr. Riley, during the course of compiling your report, do you find any indication that Mr. Ray has a substance abuse issue or an underlying medical condition?
No, I did not.
How does Mr. Ray's absence of these affect your diagnosis, if at all?
It satisfies the final step of diagnosis that Mr. Ray suffers from severe schizophrenia.
You've talked about the auditory hallucinations that Mr. Ray suffered from. Were these always the same?
No, they were not.
What was different?
2018, they began pushing the idea of a violent act.
Does the voices return in 2018 coincide with violent acts?
Yes, they did.
Thank you, Dr. Riley. You also said earlier that you conducted interviews as part of the process of making your diagnosis. Who else did you interview in the course of forming your opinion?
I spoke with Mr. Ray's father, his wife, and his former employer.
Why was it important to discuss, or why was it important to conduct these interviews with Mr. Ray's family and associates?
These interviews contain objective, firsthand observation of Mr. Ray's behavior, which are critical to making and to understanding a diagnosis of schizophrenia.
Are these interviews materials that would regularly be relied on for making such a diagnosis?
Yes, they are.
Dr. Riley, at this point, I'd like to talk about Mr. Ray's family history. Why was it important to discuss Mr. Ray's family history?
Hereditary factors, childhood traumas are informing an opinion on whether someone suffers from schizophrenia.
Why are hereditary factors or childhood experiences important in diagnosing schizophrenia?
They can increase the likelihood of someone suffering from mental disorders. Some studies suggest the risk of developing schizophrenia increased tenfold if a parent suffers from it.
What relevant information, if any, did you learn from your discussion with Abe Ray, Timothy's father?
I learned about the loss of his mother at a young age. She had abandoned him and Mr. Ray when he was just 3 years old.
Have you pause for a second? I saw opposing counsel unmute themselves.
Thank you. Objection, Your Honor. I'd just like to re-raise the objection made earlier in motions limine to preserve it on the record as to unfair prejudice.
Given the context at this point, I'll allow it to certainly be an area of cross-examination, but I'm going to persist in the prior ruling. The objection is properly preserved. It's overruled at this point. You may ask the next question.
Your Honor, if I may, I don't believe Dr. Riley was done. I simply was trying to be courteous because he was, I
appreciate that.
Okay, thank you.
Dr. Riley, if there was more to that answer, you may finish your answer.
As I was saying, I learned about the loss of his mother at a young age, at just age 3, and that when Mr. Ray described his mother's symptoms, and from Mr. Ray himself, the father, that they were consistent with schizophrenia.
What happened to Mr. Ray's mother, Abe Ray's wife?
She was institutionalized and died shortly after.
Dr. Foundation?
Let me so I'm clear. In what area do you believe the foundation was missing?
Your Honor, the foundation is missing for where the doctor obtained information regarding the fact that the defendant's mother was institutionalized.
Mr. Jeffrey, your response, go ahead.
Just the question before, Your Honor, was what relevant information did you learn from this discussion from Abe Ray? So this is still within this line of questioning.
Your Honor, may I be heard?
Yes, you may.
Thank you, Your Honor. There are no medical records that pertain to the mother's institutionalization. And for that purpose, this evidence coming in, these facts coming in, are solely being relied upon from the defendant's father, not from any medical records that were provided within this case.
Mr. Ephraim, given that offer of proof that there is no such actual data, your response?
Well, this is not a 705 issue as earlier. This is a 703 issue, as the expert has based his opinion on facts in this case that he's been made aware of through his interviews. In this case, this interview with Abe Ray, Mr. Ray's father. And as long as it is reasonably relied upon information in the field, as Dr. Riley has already testified, these interviews are part of a reasonable or are a reliable and regular part of making such a diagnosis. And the scope of my questions have limited the information that the trier of fact will hear to only relevant information to Dr. to Dr. Riley's diagnosis. This is far more probative than prejudicial under 703.
What I'd find at this point is I'd agree that the foundation or the standard under 703 is that an expert can rely on inadmissible evidence if experts in the particular field reasonably rely on those kinds of facts or data. I have not heard that, I believe, from the witness that they reasonably rely on statements of other family members regarding history of other family members. So I'll let you lay that foundation or go to a different area, and then we could come back to that. Otherwise, the judge would be. Go ahead.
Dr. Riley, are interviews with family and associates something that is regularly relied on in making a diagnosis?
Yes, it is. As mentioned before, it gives some objective findings into understanding the patient's behavior.
And so I'll finish up with this line of questioning. What happened to her?
She was institutionalized and died shortly after.
Dr. Riley, were you able to sit down with Timothy Ray and interview him in person?
Yes, I was.
Did you discuss his childhood with him at all?
I did.
What information relevant to your diagnosis did he tell you?
He had told me that he was hearing voices as early as the age of 10.
Dr. Riley, thank you. We're going to move forward in time now to the years and the months leading up to October 17th. But first, I'd like to discuss the DSM-5 again. Are interpersonal relationships relevant in the DSM-5's process to diagnosing schizophrenia?
Yes, the DSM-5 discusses impairments that contribute to dysfunction in all areas of life, such as employment, relationships, and ability to keep up with self-care.
So why was it important to interview Mr. Ray's former employer?
I wanted and needed the firsthand observations of Mr. Ray's behavioral history to form an accurate diagnosis, and impairment of employment can be a potential sign.
What information did you find relevant to your diagnosis from this interview with Mr. Ray's former employer, if any?
I learned that in April 2018, Mr. Ray was upset that his coworker was not following his directions, and so he slammed them against the wall and threatened their life.
What was happening in Mr. Ray's personal relationships leading up to 2018?
In 2015, he was experiencing auditory hallucinations or voices that told him that his wife was cheating on him and that his son were conspiring to cut him up with a knife.
Was he having it, or I'm sorry, was she having an affair?
Not at that time.
How do you know that, Dr. Riley?
Ms. Ray confirmed only in the months leading up to October 2018 that she was actually having an affair.
Dr. Riley, could a spouse's infidelity be a disturbance that triggers an episode?
Yes, it can.
Were there any third-party observations of Mr. Ray's illness?
Yes, from his ex-wife as well as his primary care physician, Dr. Giuseppe.
What did his wife, Jessica Ray, report to you?
That Timothy Ray always had issues with mood swings, that he would feel okay one minute and then the next he wouldn't be able to stop crying. He became more isolated at the tail end of their marriage. He locked himself in the bathroom for hours and would refuse to come out. He would also go long periods of time without showering.
Was Mr. Ray always like this?
No, in 2017, Jessica Ray said that he changed into this totally different person.
Did Mr. Ray meet with any medical professionals in the years or months leading up to Nathan's death?
Yes, he did. 3 times from 2011 to 2017, he met with Dr. Giuseppe.
Did you rely on the information she reported in making your diagnosis?
Yes, I did.
What relevant information did you learn about Mr. Ray's visits?
That on Mr. Ray's second visit, because of mood swings, he reported that he had anxiety and depression, but most of this was mainly about his marriage. Jessica told him that she would take the baby if he did not get any help. When he told Dr. Giuseppe this, he started to cry hysterically.
When was the last time Dr. Giuseppe saw Mr. Ray?
In 2017.
What information relevant to your diagnosis, if any, did you learn about this visit?
She thought he needed some serious treatment at that time. He looked and smelled like he hadn't showered for weeks. His hair was long, it was greasy, and she just kind of described him as being a total mess.
Did Mr. Ray report any issues to her?
When she asked if he was doing okay, he responded that, no, I've never been okay. At this point, when she asked if he had any suicidal thoughts or was going to hurt anybody, he got very defensive, started screaming at her, whose side are you on? What did she tell you? Have you been listening to my phone calls, you bitch?
No further questions at this time, Your Honor.
Thank you. Mr. Simbal, any cross-examination?
Yes, Your Honor. After everything that we've heard on direct, you still can't rule out the possibility that the defendant was malingering.
Of course, with differential diagnoses, you plot the likelihood of one or another. With medical certainty, I believe Mr. Ray has schizophrenia over malingering.
Thank you, but bringing you back to my question, you can't rule out that possibility, can you?
Of course, it remains on the differential diagnosis.
Because there's always a possibility that someone may be faking it, right?
There's always that possibility, correct.
Let's move on to some of the things that you might consider in determining whether or not someone is faking it. One of those things would be a prior diagnosis, right, doctor?
That is correct.
A prior hospitalization?
Correct.
And inpatient therapies?
Correct.
And when you have these things, you don't have to guess or speculate, do you?
Depends. Depending on inpatient service, medicine can take some time to determine diagnoses.
Well, doctor, you had testified earlier in a trial regarding malingering, right?
That is correct.
And you had stated that when you have these factors present, you don't have to guess or speculate as to the patient's diagnosis, right?
I don't recall saying that exactly.
That's all right, moving on. Let's talk about the first thing that you would consider when determining whether or not someone is faking it. Prior diagnosis. In fact, we have a prior diagnosis in this case for the defendant, don't we?
That is correct. He had general anxiety disorder, but that was because I only had him under a 3-day stay. And at that time, he denied any hallucinations and suicidal ideation at that time.
That's right. In 2010, you conducted what you called a full and complete psychiatric evaluation.
That is correct.
And as you said, at the end of that evaluation, you concluded that he had general anxiety disorder.
That is correct. I only had him under a 3 short day stay.
That's interesting you mentioned that, Dr. Riley. How long did you get to interview him for most recently?
I last interviewed him in 2018.
For how
long? For a good amount of time.
For 3 hours, isn't that right?
Yes.
You would agree 3 days is much longer than 3 hours you got to interview him for, right?
Well, and you're inpatient in a hospital, you're not necessarily 72 hours straight of interviewing. There are plenty of different medical professionals within an inpatient unit, probably a relatively same amount of time, if not less.
Sure, but you got to observe him for a longer period of time, correct?
Can you repeat that question? I'm having difficulty hearing you.
I'll project a little louder. But you did have him for 3 full days, right?
That is correct, in 2010.
Okay. And again, you did not conclude that he had schizophrenia.
No, not at that time. There was not enough time or symptoms to diagnose schizophrenia.
In fact, prior to his killing, no doctor has ever diagnosed the defendant with schizophrenia, right?
That is correct. He had only seen Dr. Giuseppe on 3 different occasions in which those were not the reasons of his visit.
Okay, so we have no prior diagnoses then. Let's move on to prior hospitalizations. The only hospitalization the defendant had was the one in 2010 where you did not diagnose him with schizophrenia, correct?
I did not in 2010. He had at that point denied a history of hearing voices as a child. He denied anything about his mother. He denied having the hallucinations at that time.
Doctor, I appreciate your answer, but my question is a simple yes or no question. He did not exhibit any of those symptoms at that time, right?
No, not at that time. General anxiety disorder and some sleeping dysfunction.
All right, so no prior diagnoses, no prior hospitalizations. Let's move on to inpatient therapies. In your cumulative comprehensive review of all the records, how many inpatient therapies, doctor?
Can you repeat that? I'm having difficulty. I don't know if it's the echo in the room. I can't necessarily make out what you're saying.
I appreciate the comment. Is there anybody else having a difficulty hearing me? Okay, I'll stand a little closer, Dr. Ed. My question was that you had, hold on just a moment. So I was asking you, you had no, how many inpatient therapies did the defendant have?
So in 2010, he had the Paxil that I gave him and told him to see a therapist. And then when the jail physician saw him, they gave him 300 milligrams of Seroquel.
Dr. I'm asking how many inpatient therapies he had, not what kind of medicine he was prescribed. How many inpatient therapies?
He would have 0 technically because he was discharged with Paxil.
So we have no prior diagnosis, no prior hospitalizations, and we had no inpatient therapies, right?
At that point in 2010, correct.
So I guess that just brings us to one last thing then, doesn't it? Malingering, which is something that you must always consider, right, doctor?
It is something you must always consider and take into every factor into the case and to determine the difference.
And the more signs that point to malingering, the more likely they're faking it.
Yes, in that sense, if there are more signs, there's more likely, but you must, again, every factor comes into account.
So that's a yes, doctor?
Can you repeat that?
So that's a yes, doctor, to my question?
Yes.
In fact, in a criminal setting, the more serious the crime, the more likely they are faking it.
Yes, but that is just correlation compared to causation.
Is that a yes to my question, doctor?
I said yes, and then I followed it with that is just correlation to causation, though.
And it's hard to get more serious than the death or the murder of your own child, isn't it, doctor?
That's a very relatively serious crime, I would say.
In fact, anytime the severity or the frequency of symptoms increases in the face of criminal culpability, the likelihood of malingering increases even more, right?
Yes, that is correlation that does increase.
An example of that would be when someone starts to suddenly act out when in police custody.
That would be correct.
The defendant started to do jumping jacks in the middle of the street when he was contacted by the police in this case, right?
That is what I saw from the materials as well as heard just before.
Another sign that increases the likelihood of malingering even more is when there are discrepancies between what the patient says happened versus what actually happened. In other words, when there's discrepancies between the stories, right?
That is true.
The defendant first told you that Nathan smashed his computer,
That is correct.
but that was wrong, right?
It was that he spilled apple juice.
And you made sure to confront him about that discrepancy
I did.
because it's important to take note of discrepancies.
Of course it is.
I mean, had your report not been upfront and honest about the discrepancy, it would be incomplete, right?
That is correct. And that's why it's included in there.
And as far as discrepancies go, that was the only one that you took into account in your analysis, that you confronted the defendant for in the report.
That is correct.
And the defendant also told you that he strangled Nathan in the kitchen.
That is correct.
But that's not what he told Detective Booth, is it?
Yes, he did tell a different story then.
He told Detective Booth that he strangled him to death in his bedroom.
That is correct.
So that's a discrepancy in the facts that he told you.
That is true.
A discrepancy which you did not confront him about.
That is true.
You omitted it,
Correct.
which means that your report is incomplete.
I would argue that I may not have. I'm sorry, I didn't really hear your last question. I'm sorry. The echo is really making it hard for me to understand your questions.
My last question is, if you fail to confront him about that discrepancy, that means your report is incomplete.
I would say my report is not incomplete. I did it to the best of my psychiatric knowledge. Not every psychiatric interview do you confront someone at every single discrepancy. There are some you do, and I did the first one that I said, in which we learn more about, but overwhelmingly, I believe that these are small discrepancies and are not enough to outweigh the schizophrenia diagnosis.
Dr. Riley, earlier you had said that if you had failed to be upfront about that first discrepancy, your report would be incomplete, right?
If I was up front.
You had earlier,
Correct.
if you had failed to mention the first discrepancy of what Nathan did to the laptop, it would be incomplete, right?
It would be incomplete.
And you failed to mention the second discrepancy in your report, right?
That is true.
No further questions.
Is there any redirect examination?
Just briefly. Dr. Riley, could believing a child has turned against you be a disturbance that triggers a psychotic episode?
Yes, it can.
No further questions.
Dr. Riley, thank you very much. I appreciate you being present. We'll go ahead and release you this time. You're free to step down.
Thank you.
Thank you. Let me check in with the defense. Does the defense have any additional witnesses or evidence?
No, Your Honor, not at this time.
All right. Are the parties ready to proceed to closing argument?
Yes, Your Honor.
The defense is also ready. Your Honor, could I request just a quick time check first, though, before we proceed?
I'm glad you asked that. I was about to do the same. I agree with you. Let me check with our timekeepers. How much time do both of you show we have remaining for each side?
Yeah, quick math real quick. Yeah, me and another timekeeper are trying to figure that out right now.
We'll give you a moment to do so. That's perfectly fine.
For prosecution, we're at 11 minutes and 23 seconds remaining. And then for defense, I believe we have 9 minutes and 17 seconds remaining. Is that right, Mr. Honea?
9, 10, 7 seconds for that last redirect.
Oh, with the, gotcha. Yep, 9, 10.
All right. So you're both in agreement then?
Yes, Your Honor.
Yes, Your Honor.
All right. I ask also before we, well, hold on a moment. My apologies. Just a second. Could you give me both of those numbers one more time?
Yes, Your Honor. For the prosecution, we have 11 minutes and 13 seconds remaining. And for the defense, Mr. Honea, just want to go ahead and put that on the record.
Yes, for defense, we have 9 minutes, 10 seconds remaining.
Excellent. All right. In that case, then, are both sides ready to proceed to closing argument?
Your Honor, I was going to request if it would be all right with the court to have a brief recess.
We can do that. I think we're a little behind some other rounds, probably because I think the ruling judge is talking too long on ruling on objections. But let's take 5 minutes, and I'll try to talk less, and we'll go ahead and take a 5-minute break and come back. Let me check the time. If we could be back at 5:05, we'll complete the trial at that point.
Thank you, Your Honor.
Thank you. We'll be in recess. right, when everyone's back, let me know. All right, we've got our advocates. If I can have our jurors check in as well.
I'm back, Your Honor.
I heard two. I definitely heard Ms. Falkenstein, excuse me. I know that one. How about Mr. Hillier? Were you there?
Yes, I'm here, Your Honor.
Thank you. Mr. Anderson, were you ready to go?
Yes, Your Honor.
All right. Let me just do one last thing. All right, we're ready to resume, we're ready to begin the closing arguments. What I'd ask is, for our jurors, we recommend that you switch back to speaker view for the closing arguments. I've done that for our YouTube videos as well. At this point, then, I believe we're ready to begin, beginning with the prosecution's closing argument. Mr. Simmel, are you ready to proceed?
Yes, Your Honor.
When you're ready, you may begin.
Thank you. The greatest trick the devil ever pulled was convincing the world he didn't exist. On October 17th, 2018, the defendant decided that he needed to make his 6-year-old son, Nathan, understand that spilling juice on the defendant's laptop was wrong. After abusing Nathan through a series of torturous actions, the defendant wasn't finished yet. He grabbed a belt, wrapped it around Nathan's neck, and pulled. Nathan fought, but he never stood a chance. The defendant then put Nathan's lifeless body in a trash bag and tried to get rid of it. And after searching for how to get away with murder, after faking a mental illness, and after killing his own son in one of the most personal and intentional ways possible, the defendant now sits here trying to convince you he isn't responsible. It wasn't really him. He just lost control. Ladies and gentlemen, don't fall for the defendant's tricks. He is the one who took a fun, loving, Frosted Flakes loving 6-year-old Nathan and turned him into this. The defendant is charged with 1 count of first-degree murder. Now, we as the people have the burden of proving to you beyond a reasonable doubt the truth of this murder. This doesn't mean beyond all possible doubt or any imaginary doubt, because all of life is open to some possible or imaginable doubt. It's reasonable doubt. Reason, logic, and common sense. Now let's talk about the law. As the prosecution, we have to prove 2 elements. First, that the defendant caused the death of his son, and secondly, that he did so with malice aforethought. Let's start with the first element. Nobody here denies the fact that Timothy Ray is responsible for killing his son. He confessed as much himself, which brings us to element 2, that he acted with malice aforethought. Now, the law states that someone kills with malice aforethought when they do so maliciously, willfully, or deliberately, and that he acts after a period of premeditation. That is, that he acts after a period of reflection. And it's important to note that this period of reflection can be mere seconds. The key is the sequence of the thought process. First, we have the consideration to kill. Secondly, we have the decision to kill. And third, we have the killing arising from that decision. Now, how does that apply here? Well, even under the most narrow interpretation of the facts, when it comes to the defendant's actions, we still arrive at the same conclusion. Well, first, we have consideration to kill. Remember, the defendant left Nathan and went to his own bedroom and reflected. And after that period of reflection, he grabbed the murder weapon. Consideration to kill, done. But let's just say that for whatever reason, you don't buy that. Okay? Let's narrow the facts even further. Ladies and gentlemen, for what other purpose do you grab a leather belt, put it around the neck of a 6-year-old child, and pull to kill? And this isn't like pulling a trigger on a gun. No. strangling Nathan to death, taking Nathan's last breath from this earth, while he stared up at the defendant with complete fear and terror in his eyes. That takes a certain level of dedication. It takes time. Think about it. You can practically hear the screams from little Nathan. The defendant pulled tighter. Nathan struggled for air, choking. He's dying. The defendant persisted. He's made the decision to kill. Nathan's heart, chest, and all of his 3'9", 45-pound little body never stood a chance against those 6'2", 180 pounds of the defendant. Nathan's body goes limp. He's dead. Nathan is dead because of the defendant's decision. At any point in time, the defendant could have let go. At any point in time, he could have released his overpowering grip so that Nathan could have lived. He didn't. No, the defendant made a choice. He stuck by that choice. And now, Nathan is gone because of it. The elements for first-degree murder have clearly been met. Let's move on to the only defense the defendant is left with: insanity. Now the burden has shifted entirely to the defense to prove these elements to you because they're the ones raising this last-ditch effort. The defense has to prove to you by clear and convincing evidence that the defendant was first suffering from schizophrenia at the time of the killing, and second, that because of that schizophrenia, he was unable to appreciate the nature or quality of his actions. But before we get into the details of why the defense comes up short in meeting their burden, let's talk about why we're even here in the first place. Of course he's going to claim insanity. He's got no other option. He can't say it was self-defense. Nathan's less than half his size. He can't say that it wasn't him. I mean, he did try to do that when he refused to give Officer Wentz his ID. But that plan fell apart as soon as Officer Wentz noticed the bloody shovel, trash bags, and everything else that was going on inside the defendant's vehicle. So what's he left with? What does he do? Pretend to be crazy. That's why we called a board-certified forensic psychiatrist to look past the defendant's act and uncover the true defendant. Dr. LaGreca explained to you, with the universally accepted DSM-5 as his guide, that the defendant was not suffering from schizophrenia. As Dr. LaGreca explained, outside of the defendant's self-serving statements made to his doctor in preparation for his fabricated defense, he never suffered sufficient symptoms for a diagnosis of schizophrenia. But let's just say that you buy into everything the defense is selling you and accept all of the symptoms that were observed prior to the death. And the defense still fails to meet their burden. And you don't even need to take Dr. LaGreca's word for it. The DSM-5 provides that in order for someone to be diagnosed with schizophrenia, they must experience at least 2 or more symptoms for a period of more than a year. Of more than a month. And of all the statements, of all the symptoms that you've heard from the defendant and the defense today, he never suffered 2 or more symptoms for a period of more than a month. The only thing that attempts to bring it all together is the defendant's practically scripted interview with the defense's doctor. Which brings us now to the interview with Dr. Riley. Dr. LaGreca told you something that you probably already knew instinctively. You couldn't script a more serious incentive to fake a mental illness than when you're being charged with murder. In fact, Dr. Riley was forced to admit himself that there's an increased incentive for someone like the defendant to make up an illness. It should come as no surprise then that the defendant made up symptoms like hearing voices, seeing triangles on the wall, and cameras in microwaves when he was getting ready for his defense with his doctor. Symptoms that he's never reported until he's being charged with the murder of his son. That interview isn't worth the paper it's written on. The defendant is not suffering from schizophrenia. which leads us to element 2. Now, Dr. LeGreco explained that the killing itself tells us the defendant could tell right from wrong. And the defendant, even though he probably didn't know this, admitted it. He said that he needed to punish Nathan for what he did. Ladies and gentlemen, you only punish someone when you understand they've done something wrong. And on top of that, it doesn't stop there. Dr. LeGreco also explained that the defendant was able to appreciate the nature and quality of his actions when he continued to increase the punishment for Nathan. At first, he yelled at him. Then he decided to whip him with a belt. And after that, he used the same hands that raised Nathan Ray to take his life away. And what did the defendant do after that? He did what every murderous criminal does when they know they've done something wrong: destroy the evidence. Not only did he look up how to get away with killing his son, but he followed through on it by deciding to bag his son's body and bury it in a shallow grave. In his own words, ladies and gentlemen, the defendant didn't search temporary insanity, nothing like it. He searched exactly what he knew he did: murder. Nothing stopped the defense, though, from calling Dr. Riley to the stand. A doctor who admitted to you he had an incomplete report because he failed to confront the defendant about a discrepancy. A doctor who couldn't rule out the possibility the defendant might be faking it. And ultimately, a doctor who came to his opinion without what he agreed were the solid basis of a diagnosis. Ladies and gentlemen, don't get sucked into the defendant's play. Hold the defendant responsible for the death of his son, Nathan. Tell him that no matter how many symptoms he fakes, no matter how much bleach he uses, the stain of his murder will not go unpunished. Find the defendant guilty, because if it wasn't for his actions, we wouldn't be here today. But Nathan would. Thank you.
Defense ready to give its closing argument.
May it please the court, opposing counsel. Members of the jury, the prosecution seems convinced that the greatest trick the devil ever played was convincing people that he didn't exist. And they want to conflate that with what happened with Mr. Ray in this case. But the truth is that Mr. Ray's schizophrenia is not made up. It's not fake. It's a real disease. And in fact, on October 17th, 2018, Mr. Ray couldn't fight his schizophrenia anymore. As his family life deteriorated, the voices dictated his reality, and he could no longer tell right from wrong. The reality of his family being taken away from him was becoming more and more real, just like the voices in his head. His wife was having an affair, just like the voices said that she would. And as the line between what was reality and what was his delusions became more and more blurred, the voices had an easier time dictating his reality, and he lost the ability on October 17th, 2018, to tell right from wrong. Now, we all know why we are here today. We are here because Nathan Ray was murdered, and his father committed that murder. His father took a belt out of his room, wrapped it around Nathan's neck, and strangled him to death. Co-counsel and I had not disputed that fact at all. Instead, we're here to ask a more important question of how did we get to the point where a father who cared about the well-being of his son enough to make him breakfast that morning was able to, like that, in a matter of minutes, strangle his son to death. Clearly, that's not the progression that a sane father would take. But we know after the close of evidence today that Mr. Ray was insane, and that is exactly what happened on October 17th, 2018. We know, and we have showed you today, two things. First, by clear and convincing evidence, Mr. Ray suffered from severe schizophrenia at the time he murdered Nathan. And second, that severe schizophrenia caused him to not be able to appreciate the wrongfulness of his actions, of his murdering of Nathan. We first showed you that Mr. Ray was schizophrenic. In fact, he'd been schizophrenic for a long time. He reported that he first heard the voices when he was 10 years old to Dr. Riley, and that his mother was abusive and neglectful and left his life when he was 3 because she was institutionalized for her own severe mental illnesses that Dr. Riley, after hearing about her symptoms, concluded were consistent with the diagnosis of schizophrenia. And that's significant because the likelihood of a child having schizophrenia, like Mr. Ray does, increases significantly when a parent has it as well. We get more evidence of Mr. Ray's schizophrenia when he joins the military, and his commanding officer reports him for hallucinations. And while Dr. Riley at that time didn't diagnose him with schizophrenia, what's significant about that interaction is that Mr. Ray's symptoms were so severe that he still had to be hospitalized, institutionalized like his mother for 3 days, because he clearly had a significant mental illness, even though Dr. Riley wasn't able to diagnose him with schizophrenia at that point. In fact, we also know that he assaulted a coworker at the same time that the voices came back and told him to start committing violent acts. He acted on those voices' commands, and he assaulted his coworker. But perhaps where Mr. Ray's schizophrenia is most apparent is in his interactions with his own family. Jessica Ray, Mr. Ray's wife, had said that he had always suffered from mood swings throughout their entire relationship, but towards the end, he would lock himself in a bathroom for hours, and he would sometimes go a week without showering. He believed his wife was having an affair 2 years before she actually was. And he believed that his wife and son were going to cut him up with a knife and leave him because the voices told him that was true. And Jessica Ray was cautious enough about Mr. Ray's mental health to tell him that he needed to go get serious mental help or she would take Nathan and leave him. And Mr. Ray did go to Dr. DiGiuseppe. And Dr. DiGiuseppe also noted that he looked disheveled, disgusting, like he hadn't showered. He was gross. And she asked Mr. Ray if he was okay. Mr. Ray responded by saying he had never been okay. And unfortunately, Mr. Ray didn't get the help he needed at that point. But that's because when the voices are dictating your reality, not even your doctor can be trusted. And that's why he accused her of listening to his phone calls, of talking to his wife, and he even called her a bitch. We also know from Officer Wentz's testimony that he observed very similar symptoms, that Mr. Ray was dirty, disheveled, unkempt, like he had been living in his car for multiple days. These are clearly negative symptoms that Dr. Riley diagnosed Mr. Ray with as indicative of schizophrenia, in addition to the voices. We also know from Officer Wentz that he was terrified he was being followed by the CIA. He could even hear CIA sirens during their altercation. And this helps put those internet searches perhaps into a broader context, because if the CIA was truly after you, what would they do if they realized that he murdered his son? Prosecution made a big deal about Dr. LaGreca's statements and how they're better or more believable than Dr. Riley's. But here is the truth of the matter. Dr. LaGreca did no work in diagnosing Mr. Ray. Dr. LaGreca took all of the work that Dr. Riley did and simply reinterpreted it to fit his own diagnosis. And of course he did, because he's being paid by the prosecution to do that exact same thing without doing any of the legwork himself, which is why Dr. Riley's diagnosis is the only correct one. We also had to prove to you today that Mr. Ray didn't know right from wrong. We know he didn't know right from wrong because during his clinical interview with Dr. Riley asked Mr. Ray if he thought what he did was wrong. Mr. Ray responded by saying that he thought he put Nathan in a better place. No more pain, no more suffering. Dr. Riley asked a follow-up question about whether or not he'd do the same thing if a police officer was watching. And he said that he would strangle the life out of his 6-year-old son if a police officer was watching. And we know that's insane because normal people don't even speed when a cop is watching because they know that it's wrong. He said he'd strangle the life out of his son. He would do it because he thought he put him in a better place. And thinking you put your 6-year-old in a better place, by killing him, rather than letting him live a happy and fulfilled life, is clearly indicative of a person who doesn't understand the wrongfulness of his actions. Ladies and gentlemen of the jury, I know that you are angry and that you demand something be done to rectify what happened to Nathan. It's probably even plausible that you want revenge, but this is a country of laws. And laws hold the social fabric together. And the law on this matter is clear. That when you apply the facts as we've given them to you, we've proven two things. One, that Mr. Ray suffered from severe schizophrenia when he murdered Nathan. And two, that severe schizophrenia caused him to not be able to appreciate the wrongfulness of his actions. And because we proved those two things to you by clear and convincing evidence, you must, if you find that, you must return a verdict of not guilty by reason of insanity. Thank you.
Thank you. It showed that the prosecution has literally 5 seconds remaining. Mr. Tsimble, did you wish to give a rebuttal in that limited time?
I would like to see if that's what the timekeepers have. Is that what you got from the timekeepers, Your Honor?
I timed it at 11 minutes, 8 seconds, and you had 11:13 to go. We can verify if the timekeepers show the same.
If that wouldn't be a problem, Your Honor, I'd appreciate that.
Your Honor, prosecution's timekeeper as well as the defense timekeeper have agreed that we're actually at 12 seconds left for his rebuttal.
Given that, if both of you agree at the 12-second mark, I'll go with the 12-second mark that you agree upon. I don't know that that changes much. Mr. Tsimble, did you want to use 12 seconds?
I'll take it, Your Honor. You might be asking yourself, why is the defense so angry? I'll tell you why. It's because they realize they haven't met their burden. They've left you with an incomplete report. Take that into account as you deliberate and find the defendant guilty. Thank you.
Thank you. All right, ladies and gentlemen, thank you very much. We have the case is submitted. I'm sorry, and it's been concluded in terms of the presentation of the evidence. At this point, if the judges would please complete your ballots and then send those off as quickly as possible. I'll ask everyone to stay online until the ballots have been submitted. And once that's done and we get the okay, we'll go ahead and do brief comments after that. But everyone feel free to relax until the ballots get submitted, and we'll check back in at that point.
I'm sorry, Your Honor. I didn't know if it was appropriate for me to join back in via video.
Actually, I'm glad you did that. I think it's going to be very helpful for the comments. So for our scoring panelists, if you've submitted your ballots, feel free to go ahead and turn your videos back on.
I'm all finished.
All right. Once I hear back from Phil that he's got those and they went through and he didn't see any blank spaces or holes and so forth, we'll get started. Actually, and that just came through. In that case, what we're going to go ahead and do at this point, since ballots have been submitted, is some brief oral comments. for the attorneys only. Because we have so many judges, what I'm going to do is ask that each judge limit themselves to one comment, maybe a comment and a half is fine. And the suggestion is either be a favorite moment from trial or a suggestion for one of the competitors. But when we start, why don't we just go ahead and take them in order as it shows up kind of on our Brady Bunch screen. Ms. Falkenstein, did you want to go ahead and go first?
Hi, everyone. I'm Jess Falkenstein. I'm a trial lawyer in Philadelphia, and I coached mock trial for Drexel, and I competed there back when I went there. I thought this round was great. For the prosecution, I thought you guys were very passionate, very good performers, confident. I like that you're standing. And your closing, I thought, was you really got to see your performance shine then. For defense, I thought you guys were very organized. Your directs were extremely easy to follow. I knew what your case was saying. Going forward, if you get to the semis, I would just suggest speaking a little slower. We're through Zoom, so everything there, it's just easier to follow if you're not speeding through. But great job, everyone.
Thank you. Mr. Anderson, any thoughts?
Hold on. All right. Yeah, my name is Don Anderson. I'm an attorney in St. Petersburg, Florida. I coached and teach at Stetson University College of Law. Been doing this for about 20 some odd years now. Just a good round. I will just say, I'm going to call two people out. I know it's two comments, but I usually don't do this. First of all, what I always say, listen to your coaches, don't listen to me because I know a lot less than they do. And I know you all are bored and you want to go grab dinner or drink or whatever, that's fine. Ms. Jackson, your prosecution opening, I really liked it. You showed a lot of passion. I thought that was fantastic. I really bought into it. I like to see that in an opening, which you don't really see that frequently. Mr. Ephraim, I got to tell you, nothing shakes you. You just, I mean, just rulings happen and you're like, all right, one way or the other, I'm going to continue to get my case. So I really, really liked that. You were excellent, and both teams. I mean, as a coach, I hear this all the time, but very, very solid performances on both parts. But thank you, and I appreciate it. Bravo to you.
Thank you, Mr. Hillier.
Yeah, absolutely. My name is Andrew Hillier. I'm a litigator here in San Diego. I've been doing mock trial in some form for about 17 years as both a competitor and a coach. I coach for USD, University of San Diego, and I've been doing that for 7-8 years now. Just generally for both sides, I felt like I have to echo Mr. Anderson's comments. Don't listen to me, listen to your coaches. If they say something that it contradicts what we're saying, listen to your coaches. For both teams, I thought the structure wasn't as strong as it could be. I felt like from the beginning of the trial, I had some idea of where you were going, but as we were going through the direct examinations, I found myself asking, in the cross-examinations, I found myself asking, where does that fit into your argument? What specific thing are you supporting by eliciting this information? So there were a couple of times where I felt like the structure as established in your opening could have been better to give me a better roadmap for what I was going to hear. For prosecution, I thought your questions, you were arguing more through content of your questions rather than ordering and relation of your questions. So I felt like you could have been more paint by numbers in the questions themselves. And then for the defense, I liked your organization, but I felt like, especially at the very beginning of your presentations, you lack some dynamism. Give yourself a little bit more time and attention, or give the very first thing that you say to the jury, whether it's in your first open or your first cross-examination, give that first 30 seconds or a minute a little bit more dynamism. Show that you are invested in the case. But I'll echo what the other jurors said. I really enjoyed this round. I think you all did a really nice job.
I'll wrap up quickly, and I'll go less to substance since I wasn't scoring and I'm watching for different things. My name's John Madden. I'm actually not only a trial coach for Denver University, I'm actually a sitting judge in Denver as well, which is not proof that I know what I'm talking about. It's just proof that you're going to get bad rulings in real life too, because judges will make the same dumb rulings I probably made today. I did want to say there was an issue that came up that's worth probably commenting on with some objections to mischaracterizing the evidence, which I think we're really kind of coming to we think the witness is saying something that's not really in their statement. Now, hopefully, as all of you know, under the trial rules for this competition, there's really no beyond the record objection. And generally in real life, mischaracterizing the evidence is a common law objection that almost always applies to the question, because the question is mischaracterizing some prior testimony. If the witness is saying it, it is evidence, so it's not mischaracterizing evidence. But be sure ready to say the better way to deal with that is to look at the impeachment and say, can I impeach this witness, and point out that they've added something that wasn't in their statements. Especially tournaments like this one, we've got people who are coaches or been prior competitors. I think they understand pretty quickly of, oh, I see a witness who's inventing facts, and they keep that in mind. I'd throw out, since we're all getting used to this whole process of how to do Zoom trials, a couple times some of the exhibits were up a little too long. It was detracting from what we could see with you. Sometimes you nailed it, but occasionally they were up long enough that it'd say it's hard to judge and score you because the entire Zoom screen is being taken up by the exhibit. So if you're not actively referring to something in an exhibit, or it's not complementing something you're saying at the moment, consider if you should probably take it down. And then the last one is everybody's learning the hard way is if technology can fail and find some way to be a problem, it will every single time in a trial. I'd suggest if you're going to be standing up and moving back from the monitor screens, I don't think this is a score thing, but it's to make sure that you get scored well. I'd suggest investing in the lapel mics with the Bluetooth connection so that we can hear exactly what you're saying. Otherwise, the laptop microphone won't mess with you. But other than that, I thought it was an excellent round, at least from my perspective. I enjoyed the arguments you had on the objections. I think we're all set to go. Good luck. I don't know who's going to move out of this round, but good luck in getting to the semifinals. And to our scoring panelists, thank you so much. You're all set to go.
Thank you, Your Honor.
Thank you, everyone.
Thank you.